Committee meeting. My name is Maria Serpa. I'm the chairperson of the committee. Before we convene, I'd like to advise all individuals observing or participating in the meeting that the meeting is being conducted consistent with the provisions of Governor Gavin Newsom's Executive Order N29-20. Participants watching this webcast will only be able to observe the meeting. Anyone interested in participating in the meeting must join the WebEx. Information and instructions are posted at the website. I will announce when we are accepting public comment on the various issues, and the meeting moderator will assist by opening the lines as appropriate. I have advised the moderator to allot 2 minutes to each individual providing comments. This approach is necessary to facilitate this meeting and to ensure the committee has an opportunity to complete its necessary business. I appreciate everyone's understanding and patience as we navigate through this meeting format for our committee meeting today. Before we get started, I'd like to ask the staff moderating the meeting to provide some general instructions on how to participate at the appropriate times throughout this meeting.
Hello, this is the moderator of the meeting. Welcome to the Enforcement Committee meeting. Before we get started, I would like to remind board members and senior staff who are not speaking to please mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief friendly reminder or simply mute your microphone. To facilitate public comment today, we will be utilizing the WebEx question and answer feature. When the chair reaches a point in the agenda in which public comment is appropriate, public comment will be requested. At the chair's direction, I will turn on and announce the opening of the Q&A feature. As a reminder, if a member of the public would like to participate in public comment, they must enter the WebEx event through the link provided in the agenda. Members of the public can indicate that they would like to make a comment by clicking on the icon with a question mark within a square located at the bottom center of their WebEx screen. We're sharing instructions on the screen right now, and these will be shared each time for your reference. In the Ask field, typically in the lower right-hand corner of your WebEx screen, members of the public who wish to make a public comment will type, "I would like to make a public comment," and send to all panelists. Any other communication will not be responded to. It is not necessary to identify yourself in order to make a public comment, and I will take comments in the order they are received. I will call on the member of the public and unmute their microphone. That member of the public will be given 2 minutes to make their comment, and I will provide a 10-second time warning, and at the conclusion, their microphone will be muted. We will then move on to the next member of the public who has a comment. Please note that the Q&A feature is only being used as a means for members of the public to represent they would like to make a verbal comment. Once unmuted, the member of the public may verbally state their comment. This is not a means to ask questions of the moderator or members of the board. Such inquiries submitted using this feature will not be answered. If any attendees utilize a profane name, they will not be called upon to prevent members of the public from being subjected to profane language. Where you are free to express criticism or negative views, for the sake of the members of the public participating on the call, please do not use profane language when making public comments to the board. If you do not have a microphone, please click on the Communicate at the top of your screen, then select Audio Connection, call in Audio Connection. If you need further assistance, please refer to the How to Join DCA WebEx event guide provided with the board meeting link. And this concludes my opening statement. Thank you.
Thank you. I would now like to take a roll call to establish a quorum. Members, as I call your name, please remember to open your line before speaking. Albert Wong.
Here.
Greg Lippy. He may join us soon, and we'll note in the minutes if he does and when he joins the meeting. Ricardo Sanchez. Ricardo Sanchez. We heard him earlier.
This is the moderator. Ricardo, your microphone is muted.
Okay, I'm here, Ricardo Sanchez, public member.
Thank you. Debbie Veal.
Debbie Veal is present.
Thank you. With a quorum being established, we can move forward. And as I stated earlier, our Board President Greg Lippy, a member of this committee, will be joining us as soon as he's able to, and we'll note it in the minutes the time that he joins us. The committee will now entertain any public comments for items not on the agenda. To facilitate this portion of the meeting, as I previously announced, the moderator will open up the phone lines to individuals to provide an opportunity for public comment. You are not required to identify yourself, but may do so. As we open the lines, I'd like to remind everyone that the committee cannot take action on these items except to decide whether to place the item on a future agenda. We will now open the lines for public comment.
All right, this is the moderator, and at the direction of the chair, I have opened up the Q&A feature for public comment. If you would like to make a public comment, please click on the icon with a question mark within a square located at the bottom center of your WebEx screen. We're currently sharing instructions for your reference right now. And as a reminder, if you would like to participate in public comment, you must enter the WebEx event link that was provided in the agenda. All right, we have a couple individuals who have indicated they would like to make public comment. First individual identified as Stephen Gray. Stephen, I will be unmuting your microphone, and you will be given 2 minutes to speak and a 10-second warning. All right, you are unmuted.
Thank you very much. Appreciate the opportunity to ask for something on the future agenda. Two things, actually. On the future agenda, we'd like to have an update on the board's discussion and actions on the alternative discipline process that has been discussed over the last several years and was championed by the California Pharmacists Association so well. And secondly, we would like to have a discussion on the status of using the disciplinary process, particularly the cite and fine and orders of abatement at the corporate level. We haven't heard about that, and we've lost where that is. So if you could put those two items on a future agenda for the Enforcement Committee. Thank you very much for this opportunity.
Thank you.
This is the moderator. I have muted Stephen, and we will move on to the next individual who has requested public comment. Individual identified as Keith Yoshizuka. Keith, I will be unmuting your microphone. You will be given 2 minutes to speak and a 10-second warning. You are now unmuted.
Thank you for the opportunity. Keith Yoshizuka as an individual. In 2016, 2017, of those pharmacists who, as a result of disciplinary action, had their licenses revoked and the action stayed, 3/4 of those individuals had a condition that they had to complete a course in ethics as a condition of retaining their license. This is a personal area of research for me, research interest. In 2019, that percentage dropped from 3/4 down to less than 20%. So as a future agenda item, I would like a discussion as to whether pharmacists are behaving more ethically now, or if there are other factors that led to that decline in having mandating an ethics course as a condition of probation. Thank you very much.
Thank you, Dr. Yoshizuka.
All right, we will move on to the next individual who has requested public comment. Individual identified as Danny Martinez. Danny, you will be given 2 minutes to speak and a 10-second warning. I am unmuting your microphone now.
Thank you, Danny Martinez with the California Pharmacists Association. Echo my colleague, Dr. Gray. Thank you for that shout out on the alternate disciplinary model. We are still very much interested in that issue. Again, we thought we were there in January. We are now trying to reevaluate that with the board, and we look forward to working with the Enforcement Compounding Committee on getting this done. Several of our members are anxious to get this done as soon as possible, and we look forward to seeing that on a future agenda.
Thank you, Mr. Martinez.
This is the moderator. That was the last individual who has indicated they would like to make public comment. Would you like me to close the Q&A feature now?
Thank you. Let's close the phone line.
All right. And then in addition, we also have Board President Lippy back online. Board President Lippy, if you could please unmute your microphone so we can do a quick mic check.
Hello.
Hello, we can hear you. Thank you.
Thank you.
Good morning, Mr. Lippy. Thank you for joining us. I'm glad that your technology is working for you now.
Thank you. I'm glad too. I had to switch computers.
So we are just finishing a public comment, which we've had 3 members of the public give comment. Before asking the members of the question, I will state that the alternative disciplinary process is an important issue to the committee and will be on a future agenda. That's already in the plan and in the works. But as we move forward, having received public comment, I will now ask if any of the members would like to comment on any of these items. As a reminder, we cannot discuss these items, but please indicate if you wish to express any preference to an item being placed on a future agenda. As a reminder, please remember to unmute your phone and identify yourself before speaking. And this is for the members of the committee.
This is Albert Wong. I would like to see those items on the future agenda.
Any other member comment? Okay, moving forward, we will discuss agendizing the items brought up during the public comment. Moving on, next item on the agenda is we have several presentations, and I appreciate all of the people that are presenting in our audience for attending to listen to these very important presentations today. We'll start with the item on the agenda, which is number 3, presentation and discussion of administrative case process. As indicated in the meeting materials, we will receive a presentation on this administrative case process. The presentation will be co-presented by Christina Jarvis, Deputy Attorney General, and Michelle Angus, Assistant Chief Counsel with the Department of Consumer Affairs. As we prepare for the presentation, I would like you to note that the meeting materials include a historical statistical information on disciplinary matters, and attachment 1 includes a flow chart of the general process that you might find beneficial to follow. Moderator, I ask you to open the lines for Ms. Jarvis and Ms. Angus so that they may begin their presentation.
This is the moderator. Michelle and Christina, you're able to unmute your microphones.
This is Christina.
Hi, good morning. This is Michelle.
All right, I guess we can begin.
If not, you can begin.
Okay, thank you. Good morning. I am Christina Jarvis, Deputy Attorney General for the Licensing Section of the Attorney General's Office, also known as the AGO. And as you stated, presenting with me today is Assistant Chief Counsel Michelle Angus with the Department of Consumer Affairs, or DCA. You may already know both of us. I have been with the licensing section for just over 7 years now. I have handled more than 80 pharmacy cases in those years and close to 600 total licensing cases. I am also currently the board's liaison in Northern California to the AGO. Assistant Chief Counsel Angus was also formerly with the AGO in the Health Quality Enforcement section, which handles medical board cases, before she made the move over to DCA. We can move to slide 2. It looks like we're already there. That's slide 3. Thank you. A few preliminary things just as we're getting started here. This is the code section, Government Code Section 11040, that states that the AGO represents state agencies and employees in judicial and other proceedings. Next slide, slide 3, is the Attorney General's mission statement. I want to emphasize that in all of our cases, this is our mission statement. This is what we follow and try our best to meet. But in all of our cases, our job is to represent the boards or bureaus of the Department of Consumer Affairs to the best of our ability, but also to do so the right way. As we always say, we're the good guys. And so anytime we need to make a judgment call, we have to make the decision that upholds those principles that you see here on this slide. Next slide, slide 4. This is the licensing section's mission. So there are very good reasons to enforce licensing laws summarized here. And on this slide, I emphasize that while our primary goal is, of course, to protect the public, by doing so, we also protect good practitioners by protecting the integrity of their chosen profession. So let's get into some of the meat of the presentation here, slide 5. Okay, so here we're looking at a few of the building blocks for our cases. So for purposes of this presentation, I am going to focus only on accusations because they make up the majority of cases. And for time purposes, I just don't want to get bogged down in some of the differences between different types of cases. A member of the board is going to see more accusations than all of the other types of cases put together. So I think that it's the most vital. If you have questions about any specific differences at the end, I think we'll have a question and answer period. So when a pharmacy case arrives at my desk at the AGO, I review the evidence. I make sure that that evidence is sufficient to prove violations of laws or regulations governing pharmacy. In the few cases where there may be an issue with the evidence or with the laws or regulations violated, then I would work with board staff or board inspectors in order to make sure that I understand the evidence and the law, they understand the evidence and the law, and we're in agreement about what the evidence means and which laws and regulations were violated. Then it's time to draft the accusation. And here you see sort of a summary of what actually goes into the accusation. The accusation is a public document. It's online, it's in Breeze. So it sets forth the jurisdictional information, showing that the board has authority over this license, the license history, to show which license is held by the respondent and for how long, and then the relevant statutes and regulations for this specific case. Now, the relevant statutes and regulations are nearly always tied in some way to Business and Professions Code, which I'll refer to as BPC, Section 4301, which is the pharmacy definition of unprofessional conduct. This code section sets forth the vast majority of the reasons that any entity licensed by the Board of Pharmacy can be disciplined. There are a few outliers, but even those outliers, we usually still will link back to BPC 4301 because there's a subsection that states that it is unprofessional conduct to violate any laws or regulations governing pharmacy. So for the most part, in almost every accusation you will see a 4301. So the reason for this, the reason for these sections in the accusation is that we want to give the reader, again, it's a public document, and more importantly, the respondent, information about the laws or regulations exactly, the precise subsections, not just a generality that we believe were violated. And so then we get to the charging paragraphs. This would be your first cause for discipline, second cause, etc. Now, sometimes you'll have a section for general background facts prior to the first cause for discipline. Now, background facts, I would say that every DAG probably does it different, DAG being Deputy Attorney General, but they should really only be the facts that are fundamental to understanding the charges, but nothing more than necessary. So if you have a lot of extraneous facts that never rise to the level of a violation of law or regs, you wouldn't want to put those extraneous facts into this background section. And there's a couple reasons for that. One, the accusation is going to be long enough once you get through everything on this slide. And two, you don't want to be distracting from what your actual violations are. So if you go into a lot of background facts, that may not be relevant to the case, then you can get hung up on well, wait a minute, I put them in the accusation. Now I still have to prove those background facts, even though they really don't matter for the purposes of proving a violation of laws or regulations. So then the charging paragraphs, those first cause for discipline, et cetera, will explain as simply as possible, but using as much of the statutory or regulatory specific language as possible, exactly how the facts show which laws or regulations were violated. And so again, the idea here is to be as clear as possible for a non-attorney, a licensee, potentially for their attorney, but the licensee is the one who's going to see this accusation first, so that they know what we believe the problems are. So the AGO will then send the accusation, the draft, to the executive officer, and once signed by the executive officer, it's returned to the AGO's office for service on the respondent. Now, service is by U.S. mail only by statute. Generally, and just as a matter of practice, the AGO will also serve this accusation by certified mail, but that's only for tracking purposes. When it's served by certified mail, then we get that certified mail receipt back that shows, the date that it was received and usually, hopefully, if we can read the signature, exactly who received it so that we can say that the respondent had this document in their hand at some point. Unfortunately, because the working hours of the Postal Service are the same as most people's working hours, people frequently, or sometimes do not pick up their certified mail. They're not home to receive it and sign for it, and they don't have time or they don't have the ability to get to the post office to receive it. And that's why, the main service is U.S. mail. But with certified mail, that way we at least have tracking and some kind of a receipt so that we know that the letter did get to the house, to the address at some point. Now, service is required to be on the respondent's address of record and only the address of record with the board. And as we all know, the licensee is required to keep that address current. And in fact, it's a violation of laws and regs not to do so. However, and this is just a factor of practice, sometimes we can pinpoint another address that seems more likely to be a current address. In that case, we will also generally serve the accusation on that address. Please realize, though, we have to be judicious with this. We cannot be sending the accusation and the full packet and the notice of defense to every potential or possible address that this individual has ever lived at. Where this comes up a lot is we will see that we have an address with the board that maybe the licensee put in 3 years ago or 4 years ago. And then we'll see, unfortunately, an arrest report that shows a different address that is much more recent. And so in that case, we'll say, well, this is the address that, the respondent gave or the licensee gave when they were arrested. That's more recent than the address the board has. So if possible, we'll try to also serve on that address. Per statute, the only address that we are required to serve for service to be good is the address of record with the board. But we do try to make sure that the respondent does get this paperwork and does have a chance to read it and respond. And so what's the point, right? What's the point of this whole slide, of all of this information? It's due process. Again, we just try to explain as clearly as possible for the licensee exactly why we have jurisdiction over them and their license, the statutes or regulations that we believe have been violated, and how the facts that we believe we can prove at a hearing violated those statutes. This creates a framework for the case for the administrative law judge, or ALJ, and then puts the respondent on notice to be able to respond to the accusation. An accusation is notice pleading. We do not have to put every single minute piece of evidence into the accusation, and we don't have to anticipate any of the respondent's defenses and counter those defenses in an accusation. This is simply to give the respondent notice that this claim is being made against their license so that they then have an opportunity to engage in the due process of defending their license. All right, next slide, slide 6. So the next step, after the accusation is served, the respondent must file a notice of defense. This is just a form. We provide it to them with the accusation, so they just have to fill it out, a few lines, and then check some boxes. This gives them space to say that A, they got the accusation, and then B, that they want a hearing. It also gives them an opportunity to indicate if they're interested in a settlement or to surrender their license even. And then it gives them space to provide their preferred contact information as well as their attorney's information, if any. So in a case where a respondent does have an outdated address of record, but they did receive the accusation packet, on this notice of defense, they can say, please send mail to my new address. That does not change the address of record with the board because the notice of defense comes directly to the AGO. It is not an official change of address form that needs to go to the board, but it will change the address in the AGO system so that we will send future correspondence to that address on the notice of defense. Now, the notice of defense is also the request for a hearing. And so without a notice of defense, there is no hearing. We would just proceed to a default decision pursuant to the government code. So there are reasons that licensees decide not to file their notice of defense. Sometimes, of course, the licensee did not receive the accusation for some reason, and I'll get to that in a minute. But sometimes maybe pharmacies are closing and they don't want to go through the process. Maybe a pharmacist or the technician is retiring. Frankly, sometimes the licensee may have addiction or other issues, and they decide to take care of those issues first and then worry about their license later. But regardless of the licensee's reasons for making the decision, without a notice of defense, we as the AGO, and frankly, you as the board, cannot force this licensee to attend a hearing and defend their license. Now, once the default decision becomes final, if the licensee just really never got the accusation and didn't realize that this accusation was posted on their license information on Breeze, this is usually when they reach out to us. And, they're usually surprised to hear about this. And, what can they do? Well, immediately they can file a request for good cause to set aside the default. Now, in most cases, the board can always set aside a default. And in most cases, the board should really set aside any default taken for failure to file a notice of defense. It is different if the respondent fails to appear at the hearing, which I'll address at the end when we talk about hearings. But absent really unusual circumstances, a notice of defense default should be lifted to provide relief to the respondent and the additional due process that they're entitled to before they really lose their license, potentially permanently. And especially now that they have come into contact with the AGO or the board and have evidenced a desire to defend that license. All right, let's move to slide 7. So once the notice of defense is received, we basically are ready to set the matter for hearing. Now, in order to do so, the DAG and then the opposing counsel or the respondent needs to meet and confer to select dates, potential hearing dates, prior to submitting the hearing request to the Office of Administrative Hearings, or OAH. At that point, we have to take everyone's schedule into account, and that includes, both attorneys, if there's an attorney representing the respondent, any of respondent's witnesses, any of the complainant's witnesses, the DAG's witnesses, and then the court schedule as well. And so you can see that frequently, depending on how busy everybody is, frankly, you can wait 4 to 8 months for a hearing just because you can't get dates, that many people in the same place at the same time when you have so many very busy people trying to set this schedule. Now, the length of the hearing also has to be estimated, both by the DAG and then opposing counsel or the respondent. And this is really important because if you don't set the length of hearing for a long enough time, let's say you set it for 2 days and you run out of time, you can only get so much in 2 days, then when you come back for the hearing, you have to set new dates. All of these same people their schedule has to correspond so that they can all come back to the same place. You might be 2 months or 3 months later. and you're trying to remember back to what happened on those first 2 days. As a general rule of thumb, you're better off, because for that specific reason, to overestimate the number of days that you need. You're better off if you think you need 2 days, well, maybe it could go to 3 because there's a lot of documents, just set it for 3. If you get done in 2, there's no harm. But if you set it for 2 and you need 3, there is a bit of a harm. Now, if you have 4 days or more, the reason for the pre-hearing or settlement conference question there is if you have a hearing of 4 days or more, then you are required to have a settlement conference and a pre-hearing conference. Now, the pre-hearing conference is somewhat minor. It is a time for you to discuss discovery, if there's discovery issues outstanding. It's time for you to discuss, witness scheduling. Basically, the DAG and the opposing counsel or the respondent are in a room with the judge who will hear the hearing, and you just kind of discuss the process of how the hearing will proceed. After that, you have the settlement conference, and a different ALJ who is not assigned to hear the case and is not allowed to speak to the ALJ who will hear the case will go over the accusation, will talk to both parties, and then will give us their, raw, unfiltered opinion of exactly what they think of the case and what, in their opinion, would be an appropriate outcome. This is a pretty superficial review. We're going over this over the course of maybe a half an hour to an hour, nothing like the multiple days that a hearing may take, but it can be a really great way for both sides to see how this independent third party ALJ, trained the same as the ALJ who will hear the case, thinks about your evidence, up front. And the final factor here is venue. So generally, a hearing will be held at one of the 4 OAH offices statewide, either Sacramento, Oakland, Los Angeles, or San Diego. But on occasion, and usually for witness-related reasons, a hearing has to be held remotely. In the Sacramento jurisdiction, that's usually Fresno, Redding. I've had cases in Chico, or unfortunately for me, Modoc. Those are disfavored because in that case, the DAG and potentially opposing counsel and the judge all have to travel and usually stay overnight, and that's several people traveling. At this point, quite frankly, in 2020, with the specialness that this year has given us, we would probably do these witnesses remotely and have them either on the phone or on video. That is up to the agreement of the parties or an order from OAH, from the ALJ. Quite honestly, all of that is really in flux right now. We've been sort of stumbling along and making decisions on a case-by-case basis as we go, but I think in the future that we are most likely to be required to go to Sacramento, and any witnesses who can't make it to Sacramento, again speaking for the Sacramento jurisdiction, will be calling in or on video. Prior to COVID, if you have a necessary witness who's 90 years old and lives in Fresno and can't drive, we will bring the hearing right to them. We will make sure to make it as easy for that witness as possible because they are a necessary witness. Let's move on to slide 8. This is a little bit backwards because discovery is really usually done prior to setting the hearing, but it goes right into a nice discussion of settlement, and so I moved it right after the setting of the hearing. But so discovery is usually the DAG sending the investigative file to the respondent or to their counsel. And it really almost always has to happen before the matter is set for a hearing because it's almost impossible for the parties to analyze those venue and the length of hearing issues if both sides have not had a chance to review the evidence. It's very difficult to both be on the same page if we're looking at different books. Now, sometimes, particularly non-represented respondents, they don't know to request discovery. We tell them in the accusation packet that they're entitled to discovery, and we send our own discovery request with the accusation packet, but sometimes they just don't realize it. They don't realize that as set forth here on the slide, it's supposed to be a written request, and it has to be within a certain time period. So as a DAG, I certainly try to be very flexible, and if a respondent just calls me up and says, hey, I want I want to know what you're looking at. Send me the evidence. I consider that to be a discovery request. And then I will write it down that they requested discovery, and there's the written request. So, we don't hold an unrepresented respondent to the standard of, essentially being an attorney, even though there are certain procedural things that they have to comply with. We will try to help them comply with them. I once received a sticky note on the notice of defense that says, "Evidence, please?" ? And I sent discovery. I consider that to be the written request. So then also at this stage, we do send our request for discovery with the accusation packet, and the respondent, sometimes, again, an unrepresented respondent, may not know what that means. And so we talk to them, we call them, and we ask for what we call mitigation under the disciplinary guidelines. So the respondent needs to provide mitigation, and we'll discuss exactly what that is later, and then the agency will decide whether or not to extend a settlement offer. A settlement offer is almost always offered, even if that settlement is only a surrender of licensure rather than proceeding to a hearing. And some people think, oh, surrender, that's a nice settlement, thanks so much. However, there are things in any settlement that can be negotiated. And so in certain cases where revocation is really going to be the best or only outcome in a case, if the respondent is aware of that, then they can negotiate a somewhat better deal in surrendering their license than in going to a hearing, paying for their own attorney and all this process, and then getting revoked in the end just a few more months down the line anyways. And every settlement is negotiable. We discuss back and forth. We will email, settlement offers, counter offers, et cetera, and have, conversations with opposing counsels and with the respondents as to any concerns about any of the settlement terms. There are many good reasons to settle. As you can see here, I've listed 3. The first being, of course, risk avoidance. You just never know what the ALJ will decide. You may go in with what you think is an excellent witness, and then it turns out that they're so nervous on the stand they have trouble articulating themselves. You just don't know what's going to happen once you're in the actual arena of the hearing. It also saves time and therefore the expense, both in paying attorneys for both sides, the respondent paying attorneys, the board paying the DAG, but then also if the respondent is found to have violated laws or regulations, then those costs are also put onto them for cost recovery. So they can save quite a significant amount of expense by settling early rather than proceeding to a hearing. And then the time, instead of waiting months, as we talked about when we talked about scheduling for a hearing and then the proposed decision and then the board's vote, we can usually have a final resolution, because the board will still have to vote on the settlement, within about 60 to 90 days of that settlement being signed. So that's a lot quicker than potentially a year from the time that the accusation is filed. And then lastly, and this may be obvious by now, but stipulations are good. Settlement agreements can contain any term of agreement that is not contrary to policy or law. So the parties really can get creative with the terms, and they can tailor those terms to the violations. The parties, again, can negotiate the terms. And then finally, the terms are binding on both parties, but the respondent is the one essentially that has to comply with the terms of the stipulation. And in this case, the respondent has agreed, in the case of a settlement, the respondent has agreed to the stipulation. They've signed it. They've agreed to abide by those terms versus going to a hearing and having terms that the respondent may completely not agree to, may completely have no idea could even be imposed on them, then being imposed after a hearing. So all in all, stipulations are good and should be promoted at all times. And that may sound a little bit odd coming from a DAG. As essentially a prosecutor, a specific type of prosecutor, you would think that I would want to be in hearing all the time. And that's true. I do. I wish I could go to hearing as much as possible. It's much more fun than sitting at my computer and typing up a stipulation. but in the best interests of both sides, stipulations are good. So let's move to slide 9. And this brings us to the disciplinary guidelines. Now, the disciplinary guidelines, and I hope that everybody is familiar with them, they are completely vital to any case from start to finish. And if I leave just one impression to anybody listening to this presentation, it's to go read the disciplinary guidelines. The disciplinary guidelines, I call them the DGs, will give direction to board staff, to myself. I keep them handy on my desktop, on my computer at all times for every board that I deal with regularly. It also gives guidance to the respondents or to the opposing counsel as to what they can expect from any given case, any given violation. And then finally, this also gives direction to ALJs, and even in the case of a Superior Court writ, which we'll discuss a little bit later, the Superior Court may review the disciplinary guidelines. In every writ I've ever handled, I've included the disciplinary guidelines, and the judge has reviewed them. So they're very, very important. So let's move to the next slide and talk about what's in the disciplinary guidelines. So the very first page, the board's primary purpose is to protect the public. And the board has actually a fairly lengthy and articulate statement about exactly what the purpose of the disciplinary guidelines is and what the purpose of the administrative case process is. I'm not going to read the statement, but that's the first thing is here's what the board thinks, here's the reason for these guidelines. The next thing in the disciplinary guidelines are factors. These are factors to be considered in determining whether the penalty in any particular case should be a minimum penalty, a maximum penalty, or an intermediate penalty, somewhere in the middle between minimum and maximum. There are 17 total factors. And these factors, as with just about everything I'm going to talk about here in the disciplinary guidelines, are general factors. Not every factor is going to apply in every case. Not every factor that the board should consider is going to be listed here. These are general categories to give an idea of what should be considered and what factors play into making the final decisions. These 17 factors include an actual or potential harm to the public or to a consumer or a financial benefit to the licensee. It also includes a prior record, either disciplinary record with the board or criminal record. It includes the nature or the severity of the acts. And then it also includes, and this is maybe the most important, evidence of aggravation, mitigation, or rehabilitation. So we think of aggravation as something that makes the act worse. Mitigation is something that makes the act better. And then rehabilitation is what the licensee has done after the act in order to make sure it doesn't happen again. So the mitigation and rehabilitation information is what we generally ask for the respondents to provide at the point of discovery in order to decide whether or not or what level any settlement offer may be. And so then that brings us directly into the next page of the disciplinary guidelines, which is a list of the types of evidence that the board wants to see in recommending settlement. And this includes letters of recommendation, performance evaluations, evidence that the respondents, if this is a factor, substance abuse is being treated. And again, this is just a way to give the respondents direction, broad categories, as to what to provide to board staff for settlement purposes. But really, the meat of the disciplinary guidelines, and probably the most important part, is the 4 categories of violations. Now, these are 4 categories that the board has identified and delineated, in the disciplinary guidelines in black and white. Category 1 through 4, 1 is the lowest level of violation, and then 4 is the highest. Now, each category, again, outlines examples of the violations, but each case still has to be considered on its own merits. Each category and the recommended discipline for each category also contemplates only one violation. So anytime that there are multiple violations, either of the same violation or multiple different violations that all fit into the same category, that should raise the entire case to the next higher category. This is a case-by-case basis. This is where discretion and judgment comes in. So you have to look at what the violations are, how many there are, how severe they are, and then determine which category they fit into. So let's move to the next slide and talk about category 1. So just preliminarily, the maximum penalty for any violation for every category is revocation, because the board has determined that in every case where there are violations of pharmacy law or regulation, revocation is a possibility. It's on the table. That doesn't mean that it's a probability, depending on the case, but it is a possibility. And you can see that as we walk through these categories, which we're about to do, because there may be some cases where just one violation, even of category 1, is so severe that it necessitates revocation in order to protect the public, to protect the consumer, and to protect the practice of pharmacy. So category 1, the minimum penalty for category 1 is revocation stayed with 2 years probation. I have rarely seen a case that is appropriate for a 2-year probation period. Generally, you're going to have either more than one violation, violations that fit into multiple categories, etc. Just one category 1 violation is uncommon. Another issue with the 2-year probation period, and it may not be an issue, but it is a factor, is that the respondent, if they're placed on probation, can then petition the board for early termination of probation after serving only 12 months of probation. If it's a 3-year probation term, the respondent can petition for modification of probation after 12 months, but they are not eligible for early termination until 24 months. That's a lot of numbers thrown in there, but the bottom line is if it's a 3-year probation term, then the respondent has to serve at least 2 years in order to receive an early termination of probation. If it's less than 3 years, then they only have to serve 1 year. Of course, any petition for early termination of probation goes before the board, and the board can make a determination at that point. Now, some of the examples of violations fitting into category 1 are violations of record keeping, scope of practice, or inventory control requirements, or failing to adequately supervise staff, or to ensure the security and sanitation of the premises. Excuse me. Throat's drying out. All right, let's move on to slide 12, category 2. The minimum penalty for category 2 is the revocation stayed for a 3-year probation term, 5 years if the violations involve self-administration or diversion of controlled substances, dangerous drugs, or alcohol. Now you can see the rationale for this set forth on the slide. These violations have a serious potential for harm, involve a disregard for public safety, reflect on ethics, competence, or the diligence of the licensee. And my understanding of the difference between the 3-year or the 5-year probation is that just in general, studies have shown that if an addict can remain sober for 5 years, their chances of remaining sober for life will greatly increase. And our goal, of course, with any probation term is to bring the licensee into compliance, and in the case of alcohol control substance abuse issues, for them to be sober and safe to practice. Now, some examples from category 2 include failing to report to cures or other regulatory agencies, violations of quality assurance or self-assessment obligations, or failures to clarify erroneous or uncertain prescriptions. Now, that is a very brief coverage of the examples from category 2. Category 2 is a large category. It's really the second largest category after category 3. So if you have questions about what actually fits into category 2, I highly, highly recommend, again, reviewing the disciplinary guidelines for yourself. So if we move on to slide 13, we'll talk about the largest category, which is category 3. Now, the minimum penalty for category 3 is the revocation stayed, and then here we see our first suspension, a 90-day suspension, and then 3 to 5 years probation for the same reasons as set forth in category 2. Now, a suspension is an interesting sort of animal. A suspension can be virtually any length as determined to be appropriate by the board, with a few caveats. First of all, a suspension that is so long as to be essentially indistinguishable from revocation would not be appropriate. So if you're going to have a suspension that is longer than a probation term, or that is longer than the respondent would be able to apply or petition to the board for relief from a probation term, as we were talking about earlier with the 12 to 24 months, that's probably going to be too long. However, that goes into the second factor. There has to be a reason for the suspension. Why is the suspension appropriate? The purpose of the suspension is not punitive. It's not just punishment. Of course, any suspension is going to cause a financial hit to the licensee, to the respondent. But there has to be a reason other than that. For example, where a pharmacy may have poor sanitation or record-keeping practices, a suspension of 90 days could allow that pharmacy to clean, to reorganize, to revamp their record-keeping. It gives the licensee, in some ways, a forcible break from the hustle and bustle of your everyday practice to get into compliance. And once again, the purpose of all of these terms, because we're talking about probation, is to get the respondent into compliance. Now, again, the rationale is set forth here on the slide, greater potential for harm, etc. But I want to emphasize that with all violations, with every category, the key is always the potential harm to the public, to the consumer, to the practice of pharmacy, etc. So you should always think about the intent of the law or the regulation in order to see how a violation of it harms or could harm an individual. So I hear a lot, I had some paperwork errors, big air quotes around paperwork. A law or a regulation is rarely just paperwork. There's a reason that law or regulation has been enacted. There's a reason that it's necessary, and it protects something. It protects some entity or some principle that requires that law or regulation to be enforced. Now, here are some examples that fall under Category 3 are failing to exercise your corresponding responsibility, violation of laws governing controlled substances, dangerous drugs, devices, etc., which include repeat or serious diversion or self-administration, or dealing with adulterated, misbranded, or expired drugs. And again, many, many more. This is the largest category, and probably most cases are going to fit into Category 3. And I say that with big caveats because it's really hard to generalize that, again, because multiple violations of Category 1 or 2 might push a case into Category 3. And so let's move on to slide 14, which is Category 4. The only penalty appropriate for a Category 4 violation is revocation. Now, this category is somewhat small, but again, remember these are generalized ideas more than a specific list. But these examples include possessing a controlled substance for sale, transportation, importation, or use of a minor for unlawful sale of controlled substances, criminal convictions involving the same, or then again, as you see here, repeated or serious violations that fit into one of the other three categories. So once you get to Category 4, there's really only one result that should occur. There is always, of course, an opportunity for a discussion of mitigation or rehabilitation issues, but at this point, the violations are so severe and so pervasive that it's unlikely that we could settle for anything less than a revocation. All right, let's move on to slide 15. So that gets us through the categories. And the next thing in the disciplinary guidelines is model language for settlements and then for the proposed decisions written by the ALJ. Now, these model terms, these model language is important because consistency in the terms of probation is appropriate, even while each case is being decided on its own merits. So just as kind of a brief example, you could have two identical DUI cases. Say two people who get caught at a DUI checkpoint, each has a 0.8% or 0.08, blood alcohol content or BAC. And so all other factors being equal, they should probably be treated the same. They should have the same terms. They should have the same drug testing. They should have the same. However, if somebody, let's say, blows through a red light, T-bones another car causing serious injury, and has a 0.3% BAC, and I do mean 0.3, and I've seen it, that person should probably be treated differently than the previous two. They need to be required to get help with what appears to be a serious alcohol problem. Now, in each of these scenarios, the licensee is likely to be convicted of DUI, single conviction DUI. But you can see, the purpose of these scenarios is to show exactly how different the exact same conviction can be. In every term of probation, there are 16 standard terms that should be ordered in all cases. These include to obey all laws, file quarterly reports to the board, and cooperate with board staff. These are sort of generalized terms that are essentially the meat of being, quote, on probation, and everyone should have to comply with them. And then there are 26 optional terms of probation, and each of these terms need to be considered in each case and only ordered in the appropriate cases. Now, some of these terms will work together, such as abstain from drugs or alcohol, and then drug testing. So if the respondent is ordered to abstain from drugs or alcohol, but does not order testing, then there's really no way for that abstention to be monitored or enforced. The only way that we would know if the respondent violated is if they essentially got arrested, and then we'll have those drug tests. But, the way that the board's program works at this point is if you're ordered to abstain, you are also ordered to test. And that way we can be sure that you are in fact abstaining. Now, other terms are designed to educate the licensee. And again, to bring that licensee into compliance. And those terms include like remedial education, an ethics course, additional continuing education courses, or supervised practice. And once again, all of these terms are designed to protect the public. And the variety of these terms and the implementation of these optional terms goes right back to that idea of settlement. In a settlement, the board can ensure that the appropriate optional terms are included in the order. With a proposed decision, the DAG, someone like me, can make that request to the ALJ, but there is no guarantee that the optional terms that the board believes are appropriate would be ordered. Now, I had a case once with a different board where the ALJ actually put two incompatible terms in the order. So the licensee just really could not comply with both terms. It was a little bit vague, and it depended a little bit on how you interpreted a few words in the language. And so the board really didn't realize at the time how incompatible these two terms were and adopted the decision. That mess took 2 years and 2 different writs to sort out. Now, I don't think that the Board of Pharmacy has any incompatible terms, and obviously this case was an outstanding circumstance with very difficult people involved, but it's a cautionary tale. We could have saved hundreds of hours and thousands of dollars if we had entered into the same settlement at the outset that we ultimately agreed to 2 years later at the end of all this litigation. Let's go to slide 16. We are getting towards the end here, so I think I'm probably running out of time. But I want to emphasize that all of the process, everything that I have discussed so far this morning, has 2 guiding principles that always must be held in balance and always have to be kept in mind when you're analyzing any case. And those 2 principles are the due process for the respondent and then the protection of the public. These 2 factors can really be at odds. You may have a case that somebody might look at and say, this is an emergency. We have got to revoke this respondent's license. But you can't. In order to protect the public, revocation immediately might be the best thing to do. But that respondent has a property interest in that license, and they cannot be deprived of that interest by the state, which is the board, without having due process. Now, there are a few things, an ISO or other process that other types of actions that we can engage in order to get a suspension. but we cannot get a revocation without going through the actual full due process. However, the licensee also receives their license from the state, from the board, and the state has the right and the responsibility to ensure that licensees are competent and trustworthy. And you may get the idea that I'm quoting because I am directly from the case that you see on the slide in front of you, the Shea versus Board of Medical Examiners. These are the two fundamental factors that are the push-pull in every case. Now, when I'm preparing witnesses for hearing, I always tell them that at the hearing, of course, they're to tell the truth, the whole truth, nothing but the truth. They'll be under oath to do so. And I tell them the point of the hearing is not to, big air quotes here, win. The point of the hearing is to get to the truth. So that's the whole purpose of the due process. If somehow, the evidence that we have is wrong and the respondent is not responsible for the violations that we believe occurred, we will lose the hearing. And that's okay. That is not something you hear from most prosecutors, and it's not something that I'm terribly comfortable saying, but it's true. Our purpose here is not to punish a respondent. Our purpose is to make sure that the appropriate professional and legal standards are upheld, and that, again, the respondents are compliant with the laws and regulations governing pharmacy. So let's move to slide 17. And this is basically how due process correlates with stipulated settlements. And the bottom line really is that they don't. Even where a licensee is giving up their license, there's no interaction with due process because the licensee has agreed to the stipulation. The licensee believes enough to enter into a binding contract with the board that this stipulation is better for them than to continue with the due process, the process that they are due, and proceed to the hearing. So, due process does not mean a licensee can never be deprived. It just means that we have to go through this process in order to do so, if that is the appropriate discipline. All right, next slide, slide 18. And finally, we get to the hearing. Now, the respondent may choose not to appear. It does happen. Sometimes there's a problem, sometimes there's good cause. The respondent is in the hospital, in jail, has car trouble, etc. But I've actually had cases over the years where the respondents tell me that they're not going to appear at the hearing and will just, quote, accept the judgment of the court. So then I have to tell them that's not how it works. Usually, not always, there will not be a hearing if the respondent does not appear at the hearing. Once I tell them that, they usually, and again, not always, will show up for the hearing. If the respondent does not appear at the hearing, then again, unless there's a reason, a good cause that I just mentioned, they should be defaulted because the respondent has decided, they have made the decision for whatever reason of their own that we really can't speculate on, that attending this hearing is not in their best interests. Again, if there is good cause, the board can always set aside a default, but this would have to be pretty extreme good cause. The respondent is noticed of the hearing several months in advance. The respondent has discussed the hearing with the DAG, usually multiple times, has discussed settlement. As the DAG, I always go through the process that they can expect at the hearing, how they can expect the hearing to proceed, what they're going to need to do at the hearing in regards to presenting evidence. The Office of Administrative Hearings also has a pamphlet on representing yourself at a hearing. So there's really very, very few excuses for a respondent not appearing at a hearing other than, as I said, potentially in the hospital, even car trouble. They can call, they can let us know that they're not going to be there and we can work around that. If they just don't show, don't call, the default is appropriate. Now, a hearing is a public proceeding. That means that anyone can come watch the hearing. That's a little bit harder right now with COVID because we're doing a lot of these telephonically. So you'd have to actually contact the Office of Administrative Hearings for the login information in order to do so. But you're entitled to do so. Just like we're having this meeting online, this is exactly how a hearing proceeds. And that also means that any document submitted in the hearing is a public document unless the court orders the document to be sealed. this can be a challenge for pharmacy cases because some of the documents that we submit in some cases are patient records, and we have to preserve patient confidentiality. There's absolutely no reason that any patient's name or any of their personal identifying information should be revealed at a hearing. That can be difficult. The hearing is public. But we can use redactions, and then we can use orders to seal to actually seal those exhibits when necessary. So at the hearing, the Deputy Attorney General will go first. That means we give the first opening statement, and then we actually proceed to put our case on first, call our witnesses, put on our evidence. But the reason for that is because we have the burden of proof. The complainant, the DAG, has the burden of proof to prove that what we have alleged in that accusation is true. We have to prove that case to a clear and convincing standard. And as you see here, that standard is highly and substantially more probable to be true than not. And then the trier of fact, the ALJ, must have a firm belief or conviction in its factuality. So this is not as high a standard as beyond a reasonable doubt as if in a criminal case, but it's close. I mean, it has to be clear and convincing. We're not talking about like, well, 51% it's true, 49% it's not true, so, we'll go with it. It has to be more like 75% it's true, 25% nothing. Not 25% it's not true, just, yeah. And then maybe we get to clear and convincing. But that ALJ has to be convinced. They have to have a firm belief and be able to defend it in writing in that proposed decision. So it is a fairly high standard. In discussing those documents, potential patient records, but even other documents as well, many times the documents that the DAG is presenting to prove that case will actually come from the respondent themselves, especially in cases against a pharmacy. So you have a document that was created by the respondent, who's maybe the PIC or the owner of a pharmacy. It's difficult to get those documents into evidence. And sometimes the respondent will agree, and generally, if they have an attorney, they will agree because they understand the process. But it's difficult to get a document into evidence that is created by the respondent. Because generally, in order to get a document into evidence, you call the person who made the document, the respondent, to testify to it. The DAG cannot call the respondent to testify in their case in chief. So I would have to put on my whole case, not have certain documents in evidence, and rest, and then the respondent, has to testify in their own case in chief. And I say that they have to testify. They do have to testify. If the respondent chooses not to testify, then the DAG can call them to testify. So eventually, those documents will get into evidence, but it's tricky. It's a little bit more complex than in certain other cases. So then, next slide, slide 19, after the hearing. And this is where this committee's own experiences will start coming into play here, because after the hearing, the ALJ writes a proposed decision that is sent to the board. The proposed decision is due within 30 days after the submission of the case. Now, this can be deceptive sometimes because most people think that the submission of the case is the last day of the hearing. Sometimes, though, there are post-hearing motions or closing arguments in a written brief, something like that, and that causes the case to be submitted to the ALJ potentially up to 90 days or even more after the last hearing date. Usually, though, the last date of the hearing is going to be the date that it's submitted, and the proposed decision is due 30 days after. There is no harm to the agency if the ALJ is late. So, the agency does not get penalized for the ALJ missing a deadline if that happens. The board will then review the decision, and I believe everybody on this committee has been a member of that process, so I won't belabor it. But once the decision is reviewed by the board members, they can vote to either adopt or to reject and non-adopt. Now, that process in of itself, the board members review and that vote to adopt or reject, and then any discussion that the board members may have at a board meeting is yet more due process for that respondent. So then if, after a hearing and the board's decision in order, the respondent doesn't agree with that decision, they can request reconsideration, as we see here. That may delay the final order as the board reconsiders their decision, or it may not, depending on the timing. The respondent can also file a writ of mandate. Now, that writ in the Superior Court will also afford the respondent additional due process. I get a little tired of saying due process in this presentation, but that's what this whole thing is about. Now, in the case of a writ, the Superior Court judge will exercise their independent judgment based on the evidence and the record as to whether or not the violations occurred. So the judge, when they're considering, is this a violation or isn't this a violation? That's a light switch, right? It's a yes or no. Only if the judge believes that the violation occurs will the discipline be upheld. And in considering the evidence, the judge does not defer to the board and does not defer to the proposed decision of the ALJ. They look at that with their own mind. They read the record, they read the evidence, they will listen to argument from the attorneys on each side, and then they will make up their own mind. However, once that decision of the judge is, yes, the violations occurred, then the trial court will not substitute its discretion, in most cases, for that of the board when determining whether the degree of discipline is appropriate. So long as any discipline is appropriate, that light switch is on, there is a violation, then the court will usually uphold the level of discipline that the board determined was appropriate. That was our last slide. I would like to see if Michelle would like to chime in.
I am happy to answer any questions that the committee might have, but I think you were very thorough in your presentation.
And I'm ready to answer questions as well. Thank you.
Hi, this is Albert Wong.
Okay, Albert, just a second. Sorry. Thank you, Ms. Jarvis and Ms. Angus. And before we go to getting comments, I would like to ask the members of the board if they have any questions or comments first. As a reminder, please remember to unmute your lines and identify yourself before speaking. And the first person to speak, I heard, is Dr. Wong.
Yes, I have a question on those violations by the licensee. The case usually involves the licensee and the PIC. This is reasonable, but do you normally get the CEO of the company involved when a case on those violations?
So that's an interesting question, Dr. Wong. So the way the licensing plan works for the Board of Pharmacy is the CEO of the company or the owner of the company may or may not be an actual licensee of their own. So they may not actually hold a pharmacist license. So we cannot hold their pharmacist license responsible if they don't have one for the actions of the corporation. We do, however, always list all of the officers of any corporation, which would include the CEO and any ownership structure in the accusation, because they are the people who are ultimately responsible for the conduct of the corporation. So then, if that accusation results in discipline, there are code sections that state that those owners and officers, particularly the ones with knowledge or control over the company, can no longer own a pharmacy. So it's a little bit of a roundabout way, just based on our statutes, because those people are not direct licensees, but we do list them in our accusations, and we do hold them ultimately responsible for the actions of the corporation.
So in this case incident, so the small community pharmacy versus the corporation, there's a big difference. So the CEO of the big corporation is not being responsible for things, while the small mom and pop store, they usually get the CEO get dragged on if they are licensee, right?
No, I'm sorry if that's what you heard me say. No, the corporate ownership, the CEO, is absolutely held responsible. They are an officer of the corporation. They are listed in the accusation just like the owner of any mom and pop pharmacy. So they are absolutely responsible. And moving forward, if there is either the ultimate discipline of revocation, or probation, then those individuals, the CEO or the owner of that corporate pharmacy, would no longer be allowed to own that pharmacy.
See, if a CEO of a corporation is the pharmacist or licensee, the license will be affected also?
So that depends on the facts of the case, and every case has to be analyzed on its own. It's going to depend at that point if that licensee, if they're licensed as a pharmacist, for example, if they were actually using their license, acting as a pharmacist in relation to the violations. So there's a concept called vicarious liability that you've seen, even if not in those terms, in your cases. And that's where we hold the PIC to be responsible for ensuring that the pharmacy complies with laws and regulations, right? So a PIC can get disciplined for the actions of a pharmacist or a pharmacy technician that they are supposed to be supervising. However, that pharmacist or pharmacy technician would not necessarily be disciplined for the actions of the PIC. So it kind of only goes one way. So if the owner or the CEO of a large corporation is acting as a pharmacist and violates laws regulating pharmacy as a pharmacist, then that pharmacist license would absolutely be included in the accusation and potentially disciplined.
Okay, I got one more question. We had a lot of cases involving DUI, and even a lot of those cases have single DUI, and we put them on 3-year probation. And to me, it costs a lot for them to be on probation, getting tested, and cannot have a certain duty, and or will not be hired by other people. So, do we have any statistic that the licensee with a DUI makes a lot of mistakes while they're at work? Do we have any statistic on that?
So I do not. This is Christina still. I will say, however, the issue with a DUI is that it is evidence of a problem with a substance, because these are pharmacists that we are trusting to, control, to possess and dispense these controlled substances that are ripe for abuse. So if we have evidence that somebody has abused a substance to the point that they have received a DUI, then that is evidence that, we may not be able to allow them, in the protection of the public. It's not so much an error. Although that is obviously always a potential, particularly if there's any evidence of consumption of alcohol at work. But for statistics, I don't have that at my fingertips today, no.
Okay, that's all I have. Thank you.
Any other board member comment or questions?
Maria, this is Debbie. I'd like to ask a question.
Thank you.
Ms. Jarvis, I know that as board members, when we are looking at cases, in that final step, as you mentioned, and either approving the settlement or approving the administrative hearing, one of the things we try to take in consideration is to make sure that how this particular individual or organization is being handled is consistent with how other individuals and organizations in similar situations were handled. And I thought I heard in your presentation that that's one of the things that you also look for or try to put into place. But I think you can do that better when it's a settlement hearing, because the attorneys are involved, especially you as a DAG are involved, and so you kind of know what's going on. But like when an administrative judge is ruling and handling the discipline, do they have any kind of a reference or document? I mean, obviously they're looking at our discipline rules, but do they have any kind of reference or document to make sure that the way that they're applying is consistent with how similar cases have been handled in the past?
So unfortunately, I'm not sure I can fully answer that because I don't know. I'm not with the ALJ when they're actually writing the decision. But I would say that they would generally look at the disciplinary guidelines. I am aware that all of the judges have the disciplinary guidelines because they've told me so. And then I do believe that they have a bank of decisions that they can look at. But other than that, I don't know that they have any other guidance. That's one of the reasons that the disciplinary guidelines is so important, and then also the representation of the DAG to tell the ALJ, this is what we think is appropriate in this case. But ultimately, the ALJ is going to make each decision on a case-by-case basis, and I would say that frequently when the decisions deviate from what would be consistent, that there's probably a reason in the ALJ's mind at least.
Okay. And sometimes it seems like we also have ALJs that as they're, they're assigning, I don't know what the right word is, determining the results of the case, that, the other attributes that are added to it, that they don't always get them right. And I would think that, for instance, it might be that the person has, like your case, where the person had the blood alcohol level of 30, that they would say they have to abstain from alcohol but not require testing. And that seems like those, should be related, and it seems in our disciplinary guidelines it's there. I would assume that the DAG would normally also kind of point out, okay, in this case, this is the other attributes that need to be added. Is that a reasonable comment? Because sometimes it just seems like they forget very critical pieces of it, and so then we have to kind of reevaluate the whole case.
Yeah, and I understand what you're saying. And, again, I really don't want to speak for the ALJ themselves. I will say that I think that that's one reason for the statutory scheme that we have, which is that the board then reviews the case in the end. Because you have to remember, our ALJs are great. They're highly trained, they're independent, and they do a good job. But they also are not designated to pharmacy, which is one of the ways that they stay so independent, right? On a Monday, they might be hearing a contractor case or an automotive repair case, and then on Tuesday, they might be hearing a pharmacy case. So because they don't specialize in any particular board, I think things like that sometimes can kind of slip through the cracks. There may be reasons, again, also that the ALJ might make that decision consciously, but it may also just be an error. And I think that's one reason that the board has the ability to review and to reject and send back for further process, or to request argument, or, to correct, minor typos or certain other errors. And your DCA counsel, in closed session would tell you if this is an error that is small enough that it can just be corrected, or if you actually need to have further argument. But I think that's one of the reasons that we have that process, is so that the board, the people most involved in this realm, has the kind of final say.
Okay. So really, I guess because the board does have the final say, it really is a little bit on us to make sure that everyone is handled fairly, similar circumstances, that it's handled fairly and equal to someone else in similar circumstances. I mean, I know that's easy to say, and you know better than I that it looks like similar circumstances, and you dig in a little bit, and you're like, well, no, this one isn't really. But anyway, it's kind of on the board to kind of monitor that and make sure that we're handling everybody as fair as we can.
Yeah, I mean, I think it's on everybody all throughout the process, and I think that we all try to do that, but the board is the final arbiter. They get the last word, essentially. But also remember, with some evidence, sometimes there is a factor of sort of presentation, and so that kind of goes back to that 0.3 DUI versus a 0.08, and this is just a question, I don't have an answer for it, but would it be different if one of those cases, the respondent was defiant and came in and said, you can't touch me, you can't hurt me, I didn't do anything, and the other one came in and said, look, I'm really sorry, I made a mistake, it'll never happen again. So there could be a difference there, and that could be most obvious at the hearing when the ALJ is actually, looking the witness in the eye or looking the respondent in the eye and analyzing that presence. So that's kind of the purpose of having the in-person hearing and then the board review, because you do have that way one person who is sitting there, able to analyze the presence of that person and the sincerity of that person, not just looking at it in black and white on paper. Now, unfortunately, I think studies have shown that humans in general believe themselves to be a better judge of character than they are, but it's the best system that we have now for every fallible person, that comes through here.
Thank you.
This is Board Member Wong. Yeah, Christina, you have given us a very excellent presentation, but I wish you had given to the whole board. Are you planning to, or is the rest of the board will hear your presentation, or just our committee only?
I think you'll have to talk to Ann about that.
Yeah. Okay. And I always like to see consistency, like Debbie said, and let's hope you do the best you can to be consistent on all those cases. Thank you.
Thank you.
Do we have any other board comment or questions? I have a question, or more of a thing to ponder, something I've talked to board staff a bit about over the last year. And in looking at the cases that come to us, I'm sometimes surprised that the individuals involved are fairly passive, or you refer to some people as unrepresented respondents. Those groups of people often appear to not make decisions with not a lot of knowledge and information. I find that some of the default decisions that we get are people not responding are to simple things that they could continue to practice if they would just come and participate in the process instead of just rolling over and giving up. And I'm not sure if that's all of it, but there's also, other issues that they just may not want to continue to practice their own. But I'm mostly concerned about the people that receive the information, because Ms. Jarvis went over the list of paperwork and the information that's sent out to the address of record. And we've seen parts of that in our board meeting. It's a lot of information, and it's very detailed and could be overwhelming to some. So one of the things I've asked staff about, and had several discussions with Ann particularly, was, is there a handout, a brochure, a flyer that could make it simple for the public to understand if they are in this process, what are some of the rights and choices they have, like a flow diagram like we have on our Appendix 1, or something that is not a legal document. Certainly it would be a document that would be approved and more generic. It wouldn't be something that would have to have some legal blessing to it. But how it would educate the individual that's going through this process. Do you have any thoughts?
So I do have a couple. So first of all, I agree, it's a large packet that goes out, and I will tell you that many of the respondents, the unrepresented again, and I really like to draw a distinction between unrepresented versus represented. So please understand that all of my comments here are towards unrepresented. If they're represented, A, I don't talk to the respondent. I'm not allowed to. I'm only allowed to talk to their attorney. And then B, they have an attorney who can break this down for them. So the first question out of the mouths of most of the unrepresented respondents who call me, and my phone number is right there at the top of every pleading because we want them to call me, is, what is this? What do I do? And I always tell them, and I have a spiel, and most of my colleagues have a spiel, and I think, statewide, this is sort of our general policy. I can't speak for every DAG, but I have a spiel where I say, look, you've received the accusation packet. There is a form in there. The first thing you need to do is fill it out. It's called a notice of defense, and I explain what it looks like. And, that is your first step if you want to defend your license. If you don't want to defend your license, you don't have to send that back. But, if you want to keep practicing, this is the first thing you need to do. And then I go through the process. I represent the board. I do not represent you. I cannot provide you with legal advice. And I make sure I actually repeat that several times. I've had respondents actually tell me, like, I get it. But respondents are stressed when they're talking to me, and I understand that. And so I want to make sure that they understand everybody's roles so that they do have a guidepost, a map through this process. But I tell them, I can tell you about the process. But the most important thing, I think, for almost every unrepresented respondent, and the thing that I tell them to look at first, is the Office of Administrative Hearings guide. Because they have, I think it's just a 2 or 3 page guide for representing yourself in the administrative process. And so that talks about the hearings. And in this first call, I will always tell them, we'll talk about that later. Right now we need to talk about the process that we're going to go through from here that will either get us to settlement or to the hearing. So I can, every DAG can give information to the respondents about the process. We cannot tell the licensee what to do. We should not tell the licensee, what their best option is ever, but we can tell them what the various options are. You can file the notice of defense. You cannot. You can try to settle. You can go to hearing. You can appear at the hearing. You cannot. You make the decision that's best for you as a licensee, but I can tell you what's going to happen if you pick each one of these roads. So in some ways, the DAG is their map. And I'll talk to respondents, every week if necessary, because, I go through this process all day, every day. They go through it, if they're lucky, once in their lifetime. So I understand that they are confused. And then once we actually get to that hearing, just one last thing. Once we actually get to that hearing with the Office of Administrative Hearings, the ALJ will go over the entire process with them as well. So they get a lot of guidance. The only written guidance, other than the accusation packet itself, which has everything, is that brochure from the Office of Administrative Hearings.
Christina, this is Greg Lippy. Do you believe that when you talk to the respondent at the beginning, that they understand that if they don't show, or if they don't file a notice of defense, and they think they're leaving it up to the judgment of the court or whatever, do they understand that that number one, the default judgment will happen, and that our hands are tied? If there's a default judgment, doesn't matter whether it's a Category 1 violation or a Category 4, our only way of dealing with it can be to revoke. Do they understand that, do you think?
Yes, absolutely. I'm very clear about that because, as I said during the presentation, I will have people say that to me and I say, nope, no, that is not how it works. Mm-hmm. If you do not engage in this process, your license will be revoked by default. And that is the only outcome. So either you can accept that, and that might be the best choice for you. I've talked to people, unfortunately, who are going to jail or prison for a long time. I've talked to people who are going to rehab for a long time, and they frequently will tell me, look, I just don't have the bandwidth for this. I don't have the mental health capacity for it. I don't have the money for it. And I don't care right now because I'm in jail or I'm in rehab and I'm not practicing. So they get to make that decision. But I am very clear that if you do not engage in this process, your license will be revoked, period.
Great. Thank you, Christina. Great job.
Thank you.
Well, I'm pleased to hear that if they do reach out, that they're given some guidance and some information. But I'm still surprised, I guess would be a good. At first, I was more surprised, but disappointed and surprised to see the number of default decisions, the people who just don't respond. And like Mr. Lippy was saying, that some of them are very, minor issues that they could retain their licensure if they would just, like you said, fill out the paper. So I'm still concerned about how to get the information to those people who are either passive, don't understand, or don't call. I will look at this Office's Administrative Hearing Guide to see what that looks like, because I'd be more interested if that's that or some other tool like that could be something that would be proactively sent to respondents. Like you said, they're in shock, and I'm not sure how much they read that huge volume that gets sent to them. And it's sad because, certainly all the information is presented to them and you can't handhold everybody. But I just wanted to make sure people were aware of their choices and their rights. So I appreciate all the time that you and the other DAGs spend on the phone with individuals. I think that is a tremendous service that our licensees don't realize is happening.
Well, and I have to be honest with you, it's somewhat self-serving as well, because if the respondent doesn't know the process, that makes it much more difficult for us to give them the due process that they're entitled to. But one thing I also forgot to mention is that I also will always direct the respondents to the board's disciplinary guidelines. I tell them this is the roadmap for your case. This sets forth everything, outside of the accusation packet itself, everything that you need to know as to how the board views this case and your violations and what you can anticipate happening, throughout the case. So, that's also always in my first spiel, and I also always tell the respondents, like, take as many notes as you want and call me back as many times as you want. I understand that you may not be clear on everything that I'm telling you in this first phone call. And we do what we can in order to make sure that we're all, again, on that same page in that same book when we're going through this process. But I will add also that I understand that defaults may be concerning, particularly when you look at the case and you think, wow, this just really isn't a revocation case. But that licensee has decided that it is a revocation case because that's what they want. That's what they have chosen. And there may be other things going on in their life that we really don't know and can't speculate about. There are some that just don't get the information, but as I said in the presentation, they usually call us as soon as they actually get defaulted and say, wait a minute, I didn't know about this. And I'll tell you, that rarely happens. I mean, it does happen occasionally, but it's uncommon. So take that for what it is.
Thank you.
I agree with 100% what Maria said, and I also really appreciate what Christina doing in her department. I really appreciate it. Thank you.
Before we move on to public comment, are there any other member comments? This is an important topic, and I want to make sure everyone has time. Okay, we'll now move on to the discussion for public comment. Moderator, please open the lines as appropriate.
All right, this is the moderator, and at the direction of the chair, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a public comment, please click on the icon with a question mark within a square located at the bottom center of your WebEx screen. We're currently sharing instructions on the screen for reference. And as a reminder to members of the public, if you would like to participate in public comment, you must enter the WebEx event through the link that was provided in the agenda. All right, I have one individual who indicated they would like to make a comment. Individual identified as Danny Martinez. right, Danny, you will be given 2 minutes to speak and a 10-second warning. I am unmuting your microphone now.
Thank you. And thank you to Christina Jarvis for this presentation. It is a very thorough presentation, and I personally appreciate the thoroughness. I also want to mention that this presentation actually, in my opinion, underscores the need for what we've been talking about in terms of an alternative disciplinary process. The issue of due process that was mentioned several times throughout this presentation, while it is due process, the amount of resources it takes to get to that point is what is really holding a lot of licensees and our members back. To get to the point that Ms. Jarvis made all the way through the presentation, and has several other folks have mentioned in the past, it takes an inordinate amount of money and time, and money that they may not have, all while the process itself seems to be against the licensee from the start, in the sense that there is as mentioned before, there was, you'll never or rarely ever get just a Category 1 violation. The issue of 4301, Business Professional Code 4301 for unprofessional conduct, is used for every single case. So that is going to be in addition to something else. That's already made out against the licensee, even again, as before the licensee has any chance to even figure out what's going on. The system is designed to assume guilt of a licensee in order to get to the point to where the licensee can then defend themselves. That is the process that we're trying to fix, and this presentation, in my opinion, backed up that assumption 100%. So I really, really hope that this decides to
10 seconds.
To have this conversation at the next meeting, because this is thoroughly important. Thank you very much.
All right, we will move on to the next individual who has indicated they would like
Moderator,
to make public
before
comment.
I wanted to see if Ms. Jarvis has any response. Otherwise, I wanted to make a comment.
Apologies.
And so this is Christina. My only response is just to that last comment of that this presentation sort of assumed guilt. The reason for that is because we had to walk through the whole process. I mean, I had to assume, throughout that we were going to end up getting to a hearing and a proposed decision. Otherwise, this could have been, much shorter. That's all.
Thank you. Yeah, and I'd like to also respond to that, in that one of the things that we have talked about also as we talk about the different disciplinary philosophies is that, there is the assumption of innocence because the person maintains their license unless they have a cease and desist, sometimes for many months, over a year, and sometimes, unfortunately, longer than a year. They're still practicing while the investigation and the process is happening. And so that would be under the assumption of innocence, is my impression. Thank you, moderator. I think we're ready for the next comment.
All right, thank you. This is the moderator again. Our next individual is identified as Stephen Gray. Stephen, you'll be given 2 minutes and a 10-second warning. I am unmuting your microphone now.
Thank you very much. Again, my compliments on an excellent presentation, and perhaps this could be considered as a presentation outside of the Board of Pharmacy at an association meeting or something. Second, I would like to comment that my concern over the 15-day response time period when an accusation is received. Pharmacists are in a socioeconomic group where they can and often do take long vacations. Some pharmacists, especially that work for large organizations, are also subject to reassignment for perhaps a month or a couple of months from their normal home address or their normal work site. I'd like to hear some information about just the reality of that 15-day comment period. It may have been adopted into law in a whole different socioeconomic time and may be right for some types of licensees, but it seems to me that that is a serious flaw in the system if that is strictly adhered to. Thank you.
I would like to make a comment as a board member at Wong. To answer Steve's question, I think it's probably a good idea if this presentation is being recorded. If it's being recorded, we could post on the website so all the licensee could listen to it, and the rest of the board member could look up also. Thank you.
And I can make a comment about the 15 days. That is in the Administrative Procedure Act in the Government Code, and that is universal for all licensees, so it's not specific to the Board of Pharmacy. And, you know, we do allow extra time for, first of all, for mailing, because we understand that sometimes mail can be delayed. And then there may be circumstances, like right now with COVID, we're not only waiting 15 days. I would say we never default after 15 days. It's usually closer to 30, and right now it's probably closer to 45, because we do understand that mail services have been impacted and people have been impacted. Similarly, like last year with the fires, we had some cases that were impacted by fires. I had one respondent that I know that their house burned down and that they were not receiving mail there. And so, you know, we did not default them until I got a hold of them. And in fact, that person did not default and filed a notice of defense. So we do work with them. And as I said, like the notice of defense, the failure to file the notice of defense that results in a default decision can always be overturned by the board. And, you know, my position would always be that it should be overturned by the board in order to provide that process. I agree 15 days is short, but it is the standard time period under the Administrative Procedure Act.
Thank you.
All right, this is the moderator, and we will move on to the next individual who has indicated they would like to make public comment. Individual identified as Joe Grasella. Joe, you will be given 2 minutes to speak and a 10-second warning. I am unmuting your microphone now.
Thank you. This really is not a really fair process. And the problem is that you have to go to a stipulated hearing, and that's going to cost you $100,000. So Marie, when you see that people are just giving up, they don't have the money. They got house payments. They got families. They just can't afford it. Then once you get to the hearing, which we really didn't really talk enough about, you have an administrative judge, like the lady says there. He's doing, you know, they're doing different cases every day. They don't have any idea when you start talking about USP, GMP. The judge clearly told me, I don't even know what you're talking about. Then you got Attorney General Assistant who really is not trained as a pharmacist. And as some constructive criticism, there wasn't even a pharmacist from the Board of Pharmacy there that I could talk to. So, you know, this really isn't fair. And this is the reason why we need the alternative disciplinary process. You should be able, before it goes to this Attorney General, you should be able to come up like all the rest of the boards. Don't hire an attorney or nothing. Say your case. And that's what you should be able to do without spending $100,000 or $250,000 to go to trial. Then on top of it, paying for the Board of Pharmacy's, representation. That's another $100,000. This is not fair at all. And so this is why all boards have alternative disciplinary process. You have a board of 5 to 7 members, people that know what you're talking about, pharmacists that know compounding, know retail, they know hospital pharmacy, they know you have to have a mix.
10 seconds.
And that will give you a fair due process. This is not fair due process.
This is Christina Jarvis. My only response is that some boards do have an alternative dispute resolution process. Some boards don't. Not all boards do. That's all.
All right. So the moderator again, that was the last individual who has indicated they would like to make public comment. Would you like me to close the Q&A feature now?
Thank you. Let's close.
All right, the Q&A feature is now closed.
So, and thank you again, Ms. Jarvis and Ms. Angus, for the really wonderful presentation. I understand that the presentation has been recorded, and so we will be evaluating if and where this could be available to members of the public or to board members. That's still to be determined. But I appreciate the time that you spent with us and answering our questions. This was a very meaningful conversation. So,
Thank you very much.
thank you. So, members, I would suggest that we take a 10-minute break before we move on to the future additional presentations. Any comment on that, or is that okay?
Okay.
Sounds like a great idea to me.
Okay, so we will take a break and resume at 10 after the hour. It's now 11 o'clock. We'll resume at 10 after.
And pharmacy moderator, this is Christina Jarvis. I plan to stay on, but I do not need to stay as a panelist.
This is the moderator. All right, I will go ahead and demote you. Shall I also demote Michelle Angus?
I don't know if she plans to stay on. She may just be leaving.
Okay.
Thank you.
Thank you.
Very much, Christina.
Hello, moderator. It's 12 after. Do you think we should do a roll call, or?
This is the moderator. Yes, if you could do a roll call to make sure all the board members are back.
Thank you. So this is Maria Serpa, Albert Wong, Greg Lippy,
Here.
Ricardo Sanchez,
Here.
Debbie Veal,
Here.
Albert Wong, and then Anne and Debbie Damas. Do you have anybody else that we should wait for or check on, or can we move ahead?
This is Anne. I believe you can move along as the committee's prepared.
Okay. So I would expect that Albert Wong will join us any minute now, and so we will add him when we hear that he is back. Thank you all. We will move on to item number 4 on our agenda, which is discussion of the board citation and program. Consistent with prior policy direction, members have provided to the staff the board's strategic plan. Today, we will receive a presentation by staff on the citation and fine program. Note that the meeting materials detail the relevant provisions of pharmacy and provide some historic citation and fine data. As I'm sure will be discussed, we'll be reviewing the data, and you will see a significant increase in the number of abatement orders issued in the last 2 years. This is inconsistent with the direction that the committee has, not the committee, but consistent that the board has provided to the staff at our May 2018 meeting. With that, I turn over the presentation to the staff. I'm not quite sure who is going to be making this presentation, but if you could introduce yourself.
Oh, sorry, it's Anne, and I will be providing the presentation. Got to just say, feeling a little bit of extra pressure after following Christina Jarvis. So we'll just kind of really get started. I think that at the beginning, what I would say is after we've gone through the presentation, moving forward, this is intended to be meaningful for the members. So if there's additional data points or other items that you would like us to incorporate in future presentations, please let us know. So next slide, please. Thank you. Sorry, if you could go back one. Thank you. So as Maria indicated, the meeting materials include many of the relevant laws that really define the board's citation and fine program. The majority of the citations issued by the board are issued pursuant to the provisions of both the regulation as well as 4314. Of the Business and Professions Code. Next slide, please. So the board, thank you. The board uses its authority to issue citations as a way to deal with some important violations that are serious in nature but don't rise to the level of removal or restriction of a license through the process that was discussed in the prior presentation. So we use at the staff level a lot of different sources, including policy direction that the board provides to us. And so when we are making determinations on outcomes, including the level of fines, the board has indicated its policy preference is that the highest fines are really reserved for the most serious violations. In most cases, the board is limited to a maximum of $5,000 per investigation, but there are some exceptions, and one of the exceptions is provided on the slide, where the board actually has the authority to issue fines of up to $25,000 per prescription for internet drugs, for unlawful internet sales of prescription drugs. Next slide, please. So the board has established its policy for the citation and fine program through its regulation. And so as part of its policy, the board has detailed out what the various factors are that staff should be considering when determining a fine. And these factors, you know, are really kind of like guiding principles. You have to recognize that each case is independent. Each case has its own specific facts. So it is hard to totally benchmark, but we look at, when we're trying to determine appropriate fines, we are being mindful of the policy guidance and the factors that the board has determined are appropriate when determining or assessing a fine. And so those are detailed both in the CCR 1717.5 as well as on the slide. Next slide, please. I'm going to talk a little bit about the citation process. So in general, how it works is there's some sort of a triggering event, an investigation is opened, the investigation is completed. Once the investigation is completed, there are several different things that could happen. It's very possible that we do an investigation and we don't even identify any violations of pharmacy law. So it's insufficient evidence, there were no violations, right? If we substantiate violations, then the board has a broad spectrum of outcomes, one of which is the citation and fine. So how do we determine that? So it's the investigation, report, and evidence is going to go through a couple of levels of review. So the inspector is going to report their findings. They are the observer. They draw the conclusions. They apply what they believe are the violations of pharmacy law, if any. It then goes to a supervising inspector for review. And that supervising inspector is again doing the same thing. Depending on the recommended outcome, it is then going to go to a second level of review. And that second level of review is performed by the chiefs of enforcement. And then as a collective group, the three of us meet to then review all of those cases. And the reason that we're doing that is we're working very hard to try to achieve consistency where we can. We recognize that all cases are different, but we use this second level review norming session as a way to really, again, try to be consistent as an organization. As a side note, during the second level review, we do rotate both inspectors and supervising inspectors through so that they can hear the discussion as well, and then integrate things back into our organization. Next one. So once a determination has been made that the outcome should be a citation is appropriate, we also will make a determination about whether or not that citation should be issued with or without a fine and with or without an abatement. Once the citation is issued to the licensee, they then have the opportunity to do a couple of different things. They can comply and pay their fine if there's a fine assessed. They can comply with an abatement order and satisfy it, or they can appeal. They absolutely have an appeal right. And the appeal can actually be in one of two forms. It can be as an office conference, which is a little more informal, or it can go to the AG's office in a process that's kind of similar to, but not as detailed as what Ms. Jarvis discussed during the prior presentation. Next slide, please. So this slide is really providing just some historical data. If you look at the data from the last fiscal year, about 38% of the citations issued are issued without a fine. Further, the average fine amount for those that are issued a citation is about $1,500. If you notice, the number of citations issued is kind of trending down, as well as the fines assessed is a pretty significant trend down. And then, of course, because the fines assessed is trending down, fines collected is trending as well. Next slide, please. The committee has really focused a lot of time not only on the citation and fine process, but also looking at processing times and how long it's taking the board, in this case with enforcement, how long it's taking for things to get done. So what this slide represents is it shows the average processing time from the time a complaint is opened, so the investigation is initiated, through the issuance of a citation and fine. So what you see is that we are unfortunately trending up right now. I do expect that as we continue to focus on those older cases and really start bringing down the overall investigation time, we are going to see similar decreases in this data point. Next slide, please. So let's talk a little bit about orders of abatement. So under the law, the board has the authority to assess an order of abatement with a citation. And if you recall back in May of 2018, during a public board meeting, the board really focused on, from a policy perspective, the value of citations with the ability for someone to do some sort of an order of abatement to kind of address the underlying issue. So when we're issuing an abatement order, there's different types of things that we might be doing. So we might be asking them to take some continuing education or complete a training course. There are times that sometimes we're saying, okay, so provide us with this specific documentation or detail out your plan to come into compliance with pharmacy law. So if we're asking for specific kinds of documentation, if it was a policy that was inadequate or did not comply with the law, we may say, provide us with a corrected policy and procedure as the abatement. And then we know that compliance has been achieved and the issue has ultimately been addressed. So compliance with orders of abatement typically results in either a reduction or forgiveness of a fine. So when we're issuing the orders of abatement, as we've previously discussed during committee meetings, the board can either mandate an order of abatement or can make it an optional abatement. So we can say, the fine is, $1,000, but if you complete 2 hours of remedial education, we'll reduce that fine or we will reduce the fine to 0. Next slide, please. So this slide really just kind of talks about some of the typical types of continuing education that we may assign as part of an order of abatement. And really what we're looking at here is what was the underlying violation, and then what type of continuing education do we think would help kind of shore up maybe the knowledge gap or serve as a refresher to prevent the violation from happening in the future. So as an example, if you see that sometimes we request that they do the board-provided prescription drug abuse course, right? So that's a free course, it's a day of training, has several different models, but it covers a lot of different things. So if there were pharmacy security issues or, maybe not full correspondent responsibility, but uncertain prescriptions, we may suggest or require that they complete that prescription drug abuse course. If the underlying violations were immunization related, it may be remedial immunization training. So again, the intent of the abatement is really to address what that underlying issue was to prevent it from happening again in the future. So other types of abatements that we may ask them to do, we may ask them to complete an updated self-assessment. The self-assessment form is really a tool to really help licensees stay in compliance with pharmacy law. So we may say, redo the self-assessment, do your new self-check, and really help them focus in on their actual practice and assess where there's opportunities for improvement. We may be requiring them again to provide us with updated policies and procedures. Sometimes we think that maybe it's a training issue with staff. So we may have them either give internal training to all staff and then provide us with documentation of it, and or provide in-services to staff on a specific topic. Next slide, please. Sorry, one more. So this chart, I think, really does demonstrate how we really have started to very robustly integrate in the order of abatement process. When the board initially started talking about the order of abatement and encouraging us to be using it with more frequency, it was kind of focused a lot on medication errors. But what we have found, and as staff, what we've been doing is looking for all citations that where the violations seem that they would lend themselves to some sort of order of abatement. And that ties in with the previous slide where I was giving some examples of the types of abatements that we may be, either mandating or encouraging to resolve the citation. Next slide, please. So one of the things that the committee was looking at last year, and the data was still a little bit new, was when we issue orders of abatement, what is our compliance rate? What are we looking at in terms of people self-selecting to either complete and comply with the abatement, or people just choosing to pay the fines? So when we look at the total number of abatements that were issued in 1920, 118 of them are still open. So that means they haven't, either because of timing or, the time periods provided, they have not demonstrated or completed it yet. And that's totally understandable given how, everything moves through the years as they are. But 281 of them have been closed. So our data systems are a little bit limited, but what we did do is we took a random sampling of those closed abatements and kind of drilled down a little bit more. So of the 25% that we looked at, 8% of them were mandatory. So that means that we said to them, you've got to do the abatement. The other 92%, however, were optional. So we said, if you do this abatement, then we will reduce your fine or we will forgive your fine. And so the licensee had a decision point that they got to decide what to do. 70% of those people elected to comply with the order of abatement. 30% actually decided just to pay and be done. Next slide, please. So we have found that there are certain violations in addition to the medication errors that really do seem to lend themselves a little bit more to abatement. So some examples are detailed here. Violations where the pharmacy is not clean, we may require them to provide photos demonstrating that they're clean. If it's a pharmacy security, I already talked about the fact that the pharmacy law and then the immunizations. Next slide, please. So as I mentioned a little bit earlier, licensees are always given the opportunity to appeal a citation, and they have different mechanisms by which they can do that. So they can pursue it through an informal office conference. The informal office conference we do consider to be part of the investigative process, so we can accept additional information and or mitigation that that the licensee wants us to know so that we can make a fair decision based on all of the information that was received. So the office conference is presided over typically a chief of enforcement as well as one supervising inspector that's present. In addition to the office conference route, an individual can also appeal a citation to the Office of Administrative Hearings to have a formal hearing with a presiding judge. In those cases, the board will be represented by the Attorney General's office. The ALJ that hears the matter will render a proposed decision similar to the disciplinary case, And then those decisions, the proposed decisions, will then go to the full board for consideration. So when we look at the outcomes of, or when we look at the volume of individuals or licensees that seek an appeal, last year, about 18% of the licensees sought an appeal through an office conference, and 2% sought an appeal through the AG's office. Next slide, please. So let's look at some of the outcomes. So of the 216 office conferences, we have various outcomes. And to me, it's very interesting to note that the data suggests that participation in the office conference really does provide the licensee an opportunity to provide that additional information and present mitigation. And it really can lead to modifications of the citation. Sometimes it leads to a reduction to a letter of admonishment or even dismissal. Next slide, please. So this slide really represents the top 10 violations that we have assessed to a pharmacy that resulted in the issuance of a citation and fine. So as you can see, by far the most common violation assessed to a pharmacy is medication errors. There's a huge drop when you go to then the safety and security of the pharmacy, keeping the records open, and it moves down from there. This slide in particular and the information on this slide, I believe, lends itself very well to a newsletter article so that it just really tries to help keep these types of issues on the forefront of our licensees' minds. Next slide, please.
And this is Debbie. Oh, there we go. Okay.
Are you okay?
Yeah, we were on the wrong slide. We were on.
Okay. So now this slide now talks about the top 10 violations for pharmacists, right? Last slide was pharmacies. This now is pharmacists. And again, you note that the top one is a medication error. The next one down, not as big a drop as with the pharmacies, but then an erroneous or uncertain prescription, followed by compounding requirements, and then unprofessional conduct. Again, I think that this is the type of information that would be helpful to include in a script article. And what may also be helpful for pharmacists specifically is providing one or two case samples for some of the more frequent violation types. Again, focusing on how can we educate the licensees to understand and perhaps to avoid common mistakes being made. Next slide, please. As we transition to both the interns, and you'll notice it with the technicians as well, the top violations are really not necessarily about practice now, but are really more about the 4301 unprofessional conduct related to self-use, convictions with self-use. So you see this frequency. We don't issue as many citations to interns. They're not as large a portion of our licensee population. So that's part of the reason that the numbers are lower. But typically, these are the top violations for interns. Next slide, please. And then here we have the text. And if you note, the number of citations has increased. That's our licensee population with technicians is far greater than interns. We're talking, probably 70,000 different, maybe not quite that much. So again, if you're looking, we've got self-use, convictions of a crime, commissions of acts involving moral turpitude. Again, these are the top violations for which a technician is going to be issued a citation and fine. So if we could move on to the next slide, please. So the committee and the board have also been very interested specifically in failure to provide patient consultation. So this slide is really just talking a little bit about what we find with the data for that specifically. So as you know, under the law, there are various provisions and various triggering events that require a pharmacist to initiate patient consultation. So what we have found in the fiscal year 1920, and it's not a full year, we issued 64 citations. That 64 is a combination of pharmacists and pharmacies. So of those, 30 went to pharmacies. And if you notice, 23 were issued with a fine and 7 without. If you also note, the average fine amount for failure to provide patient consultation was a little over $3,100 for the pharmacies. Jumping to pharmacists, what we find is that 34 of the citations were actually issued to pharmacists, 12 with a fine, 22 without. And if you note, the fine amount assessed to an individual is significantly less than the fine amount assessed to a pharmacy. So the patient consultation failure to comply with the duty to consult can take shape in a couple of different ways. It could be a patient presenting at a pharmacy in person, but it could also be failure to notify individuals of their right to consultation. If we could move to the next slide, please. So that's kind of it in a nutshell. As I indicated at the beginning, would be very interested in not only what was, happy to answer any questions, but also find out if this is meaningful, or if there are other things that would be more helpful or also interesting data points for the committee moving forward.
Thank you. Before we go to public comment, I would like to ask members if they have any questions or comments for Ann. As a reminder, please remember to unmute your line and identify yourself before speaking. Oh, I forgot. Before we go on to member comment, I just wanted to confirm that Albert Wong has joined us. I see his phone is unmuted. So Albert, if you are there, just let us know. Otherwise, let's move on to any member comment on the presentation on the board citation program.
Yes, this is Ricardo Sanchez. Just want to say, Ann, that's a great presentation, and thank you for always staying on top of that. And
thank you, Ricardo.
Maria, this is Debbie. I have a couple questions for Ann.
Go ahead.
My first question was, in one of the slides you had, you talked about optional abatement, and that people could either, just pay a fine and be done with it, or kind of stop doing what they're doing, and quite often that would result in no fine. Is there like a category of situations where people just pay the fine as opposed to, as opposed to fixing the problem? I'm just curious, what kind of a situation would you just pay the fine and not stop doing what we've asked you to stop doing?
So moderator, I believe it's slide 12 that Ms. Veal is referring to. So I think, Debbie, that you're talking about the random sampling that we did and why someone would choose to just pay the fine. So I can't speak to the motivation. What I can say is that a lot of times we will be offering the remedial education, the CEs, right? And we're using that as an option for people. We're not requiring it. So for a variety of reasons, I suppose someone could just choose to pay the fine in lieu of completing those additional hours of continuing education. If it was an issue that that staff believed had to be remedied, we would not be making the citation, the abatement, optional.
Okay, thank you. That's kind of what I was hoping you were going to say.
Yeah.
Then I have one other question. Is earlier in your presentation, you made a note that the dollar amount of the citations have decreased, and I think it was in the last year or so. Do you have a comment on why that happened? Was that at some sort of direction from the board, or I know a couple of years ago it seemed like we had like a lot of internet type issues, so maybe they're going away, and now we're kind of dealing with more of the onesies. Anyway, can you just comment on that?
Yeah, I think that it's a little bit of a combination. The internet stuff we have not seen, I have not at least seen in a number of years. So I don't necessarily know that it's that. I do believe that the board has historically expressed concern with some of the higher fines and how the fines were potentially being assessed, and, you know, really wanted to place some strong emphasis on an individual's ability to pay. And so I think at the staff level, we're trying to be very mindful of that, trying to incorporate in the feedback that has been provided by you all as the policymaker.
Okay.
I can add this is Greg Lippy. I can add something to that, and that is that we have leaned more towards saving those higher fines for those where there were multiple violations and not for single violations. Also for those where there were repeat violations. So I think in the past there may have been higher fines given where there were not repeat violations, and now that's pretty much gone.
Okay. Thank you, Greg. Thank you, Ann.
Mm-hmm.
Any other member comment?
Yeah, this is Albert. I have a comment. Thank you, Ann, for the presentation. Also, I noticed that the citation and fine have been decreasing in the last 2 years. I think that probably show us that we do more educating than cite and fine. That's good. And also, all I want you to do is, I know all the cases are different. You know, each case is different. But I would like you to do your best to be fair and consistent. That's all I like to see. Okay? Thank you.
Yeah, Albert, and so that's why I talked a little bit about the norming process, because really we are trying very hard to organizationally be consistent, and that's really what that norming thing is all about.
Very good. Thank you.
Yep.
Any other member comment? I have a question for Ann, and it may be difficult to answer, but I'm looking for like a comparison of the two presentations to talk about, because one of the things that we have had members of the public bring up is how much time it takes to go through different processes. And, you know, so earlier we had a presentation of the administrative case process, and now we're looking at the board citation program and process, and there are opportunities for office conversations that happen and a discussion fairly quickly during the citation process. So, Ann, maybe you can compare and contrast the two programs and how they work together, I guess is the easiest way I could ask the question.
Great. Are you looking, Maria, at the difference between the two appeal processes within the citation realm, or are you saying to compare the appeal process, AG appeal process that is afforded for citation appeals, to that of the AG process for disciplinary matters?
Correct. So the second part, which is regarding the citation appeals, and how most of our cases that we are looking at are regarding citations, and the process starts with you in the office you just went through, and very rarely gets to an AG type of case where the disciplinary issues are.
So I may need to understand a little bit more about what you're looking at. in terms of if you're looking for data on the appeal process and the timeframes, we can absolutely pull that and either provide it at the July board meeting or incorporate it into a future, a future presentation.
Okay, I think that would be fair because I kind of came up with this question just during your discussion and haven't had really a chance to formulate it well. But I think I'm just trying to answer the question that we've had from members of the public about the different processes and the perception of how much time it takes to go through the processes. And so that some sort of evaluation of that would be helpful at a future meeting.
Sure. Yep. I'm making a note. You can't see it, but I'm writing it down.
Okay. So now we'll open the discussion to public comment. Moderator, please open the lines as appropriate.
All right, this is the moderator. At the direction of the chair, I'll be opening up the Q&A feature for public comment. All right, members of the public, if you would like to make a public comment, please click on the icon with a question mark within a square located at the bottom center of your WebEx screen. I'm sharing instructions on the screen for reference. And then as a reminder, if any member of the public would like to participate in public comment, they must enter the WebEx event through the link provided in the agenda. All right, and we do have an individual who has indicated they would like to make public comment. Individual identified as Stephen Gray. Stephen, you will be given 2 minutes to speak and a 10-second warning, and I am unmuting your microphone now.
Yes, thank you for the opportunity, and it was an excellent presentation. I want to make a comment that I'm really pleased to see that you're using the abatement process. I think that's an excellent move, and I like what you mean. I'd also suggest that back in 2018, when we had that discussion, there was talk about using the abatement also for things that would help the PIC. So when the PIC has a problem with consultation because there's not, a confidential area or enough staff, that was something that's out of the PIC's control. When the PIC doesn't have enough security systems, doesn't have enough computer systems to handle things, or doesn't have enough space for even retaining records. So perhaps we should go back to those types of things to help the PICs. Also, to comment, I don't think people realize that if they appeal a cite and fine to the office conference, there's a 15-day time limit. There's a 30-day time limit from when they receive the cite and fine to appeal it to the ALJ. Those periods run simultaneously. Seldom do you get the office conference result within the 30 days. And so to preserve their rights, some pharmacies will appeal both of them at the same time so that they can go forward and have a fair, in their mind, a fair outcome or opportunity for due process. Thank you very much for the opportunity to comment.
Thank you, Dr. Gray.
Maria, would you like me to respond a little bit or no?
Oh, feel free to respond.
Okay. So I apologize if I was not clear. The orders of abatement are not just used for pharmacists. We also use them at the pharmacy level, and that would be an example of where we're requiring, the staff to be retrained in an area. So we do use it in that respect. If it's of interest to the committee moving forward, we can provide more detailed information in that. Just let me know.
This is the moderator. That was the last individual who indicated they would like to make public comment. Would you like me to close the Q&A feature now?
Yes, let's close the connection.
All right, the Q&A feature is now closed.
Thank you. We'll move on to our next presentation, which is item number 5 on the agenda, discussion and consideration of the board's inspection program. Members, as indicated in the meeting materials, we're going to receive a presentation on the board's inspection program. Note that inspections can be triggered for a variety of reasons, including consumer complaints, to perform statutorily mandated inspections as a condition of licensure or renewal, to perform probation monitoring activities, or on a routine basis, just to name a few. The inspection process provides staff with the opportunity to observe the practice, evaluate for compliance of pharmacy law, as well as to provide education. The board's goal is to inspect every pharmacy at least once every 4 years. I'm looking for general information as well as information on how we are progressing to meet that goal. Anne or Debbie, do you know who's going to be making this presentation?
Oh, sorry, it's me again. If you're not tired of me yet, you will be soon.
Go ahead, Anne.
So next slide, please. So why do we inspect, right? So simply put, it's consumer protection. And although I think sometimes people, when they think of consumer protection, they only think about discipline. And discipline is a very important component of consumer protection. It's not the only component, right? And so to that end, inspections provide a really significant opportunity for education as part of our process, right? So in fact, the board values inspection so much that it has established a policy goal to inspect all pharmacies every 4 years. And while the inspection provides staff with the opportunity to observe and evaluate for compliance, it really also provides a very good opportunity for education to licensees. Next slide, please. So how do we inspect? So we've provided presentations at this committee meeting on how to prepare for an inspection. We also have a video online on how to prepare for an inspection and what we do. So I'm not going to spend a huge amount of time on it, but in general terms, before we do anything, we're just going to observe what's happening. We're going to observe the practice that is occurring in that entity, in that location. And so what you see on this slide is a lot of the things that our staff are going to be observing for before pharmacy staff probably even know that we're in the pharmacy. Next slide, please. We're also going to ask for things once we're there. We're going to be looking to confirm compliance with pharmacy law, and some of that is through items that we are going to be reviewing while we're there. The self-assessment is always a key one, and as I said in the last presentation, the self-assessment form is so important. It is so important to helping licensees understand key provisions of pharmacy law and how to operate in compliance. I feel like, I say that all the time. The self-assessment form is just super important. But we're also going to look for things like, are you transmitting to cures? Are you enrolled in our subscriber alert system? We're going to look and make sure that you've got your QA policy, medication errors. We're going to be checking for policies and procedures. This is not an exhaustive list. And like I said before, if you want more information on that, would strongly encourage people to review the video that's on our website. Next slide, please. So as we're there, we're also going to be assessing types of things. We're going to be looking at the physical facility of the pharmacy. Is it secure? Is it clean? What types of drugs do you have? Are they expired? Are they in date? Just general operational issues that we're also going to be looking for. So let's talk about some of the opportunities. Next slide, please. So let's talk about some of the opportunities for education. So in this face-to-face interaction, there's an opportunity to ask questions. Licensees can ask questions. You can have conversations about things that are found in the pharmacy, as well as just general questions about the pharmacy law. To ensure or to also add to that educational opportunity, one of the things that we have integrated in are standard items that we want to make sure that our inspectors are educating on. So even if a licensee does not have questions, we are going to proactively discuss different types of pharmacy law And we do change these discussion points, you know, as the year transitions, but we do try to keep pretty standard so that we ensure that at a minimum, we know that we've covered specific items. So a lot of times we're gonna talk about the subscriber alert and why it's important. We focus right now, we're talking about some of the new laws, including like the community pharmacy staffing. We're talking about the ability for a pharmacy to relocate if it's been destroyed. We're talking about compounding. We're talking about PEP and PrEP, which are SB 159. We're talking about the warning labels, inventory reconciliation, and then again, the self-assessment. If I haven't mentioned it, we hammer home the importance of the self-assessment as well. Next slide, please. So this slide is talking a little bit about inspections in general. So how many inspections have we completed in the various years? So as you can see from the data on this slide, our inspection numbers are lower for 1920. This is in large part a byproduct of COVID-19. Similar to many other regulators, we did suspend inspections in mid-March, and we've only recently resumed inspections. Board staff have, however, transitioned to performing desk audits primarily for our sterile compounding and outsourcing facilities so that we are at least maintaining some sort of active oversight in their operations. We have recently resumed some physical inspections, but still at a lesser frequency than we normally would in recognition of, you know, the time and place that we are all in with the pandemic. Next slide, please. So here is a breakdown by type. And if you'll notice, I have a couple of them asterisked, and that's because our data system is a little bit limited. So I want you to know that these are pretty close to numbers, but we would have to have done hand counts, and we just didn't really have the time. So if you look, our routine inspections comprise about 25% of the inspections that we perform. Complaint investigations, a significant amount as well. And then our ongoing probation monitoring activities. Compounding is our biggest area for inspections. And that's in large part because they're statutorily mandated, both as a condition of issuance as well as a condition of renewal. And the same is for the outsourcing facilities. But in terms of resource, the outsourcing facilities, we just don't have the same volume of licensed population as we do in the others. And then the automated drug delivery systems, we've really seen an uptick in that area specifically as well. And that's a reflection of the change in the law that now requires the inspection prior to licensure. As you can see, we also inspect other types. Those are much smaller segments of the inspections that we performed in 1920, but nonetheless important to highlight. Next slide, please. So this slide is really kind of intended to get to the board's policy goal and where are we in trying to get out to those pharmacies. So when you look at the total number of licensed pharmacies that we have, it's about 6,500. And we conducted inspections in 1,071 of them, which is about 16% of the licensee population. So we're not close to where we need to be to meet that policy goal. What we have drawn out here is that you can see we call them all routine pharmacy inspections. That first bullet point, that 507, those are routine inspections that we did without some other kind of triggering event. So if you go down to the next one where you see completed on a probation visit, so that means we've gone into the pharmacy and we are looking specifically at the underlying causes of the probation and making sure that that is not occurring. But we are also taking a broader look at the overall operations. So that would be where we have incorporated the routine into another site visit purpose. And it gives us a good opportunity to manage our resources a little bit better, ensure that that education is occurring and that overall observation. So I'm not going to go through all of them, but I think that you get kind of a general idea of how we are approaching some of these routines. Next slide, please. So now let's kind of drill down a little bit more on that pure 507, where there was no other triggering event that brought us there. So the board performed what I'm going to call a true routine inspection on 507 pharmacies, and that represents about 8% of the total pharmacies that we have licensed right now. Of those, 204 did not have any violations. 258 pharmacies were issued 808 corrections, and I'll explain that in a minute, and 45 pharmacies were issued 123 notices, violation notices. So when we do the inspection, a pharmacy we may identify multiple corrections on a single inspection, and that's why the numbers don't match. And the same is true for violation notices. May I have the next slide, please? So this slide talks about the top 10 corrections that we're going to find or that we're going to identify during a pharmacy inspection. And so I think in the same, as I discussed in the prior slide and the prior presentation, there's kind of a spectrum, if you understand. So the violation or the correction identified may be different in one location than another, and that's because either the egregiousness of it or the other circumstances surrounding it. So you may see that there's commonalities between something, but that with the violations, and it might look like we're not being consistent, but from a practical standpoint, not doing a self-assessment, or the self-assessment is 30 days old, is a lot different than not having done the self-assessment in 2 years, right? So that the egregiousness of the issue itself sometimes can drive what the outcome is. And so this, again, I think is a really important thing that we can be doing education to licensees on. But I think for these, we have to give a little more context, because to the reader, not understanding that there's swings in what that violation or that correction looks like, it could look like the board is not being consistent, but it's actually a totality of the circumstances and the egregiousness of that time period or that the non-compliance that might drive what an outcome is. If I could get the next slide, please. So this is the top 10 violation notices that are issued on a routine. And if you notice, on the previous slide and here, self-assessment is included both times. And I've tried to explain why that may be the case. But again, I feel that this also is really good information for licensees to know about and to put on their radar as things to be self-evaluating when they're looking at their practice and when they're doing their self-assessments and really being thoughtful and mindful of their operations. If I could have the next slide, please. So this slide is intended to show where we are with meeting the policy goals for routine inspections. And I need to frame this a little bit. So we have 6,500 plus pharmacies licensed in California, but that's not a stagnant number, right? So pharmacies, change ownership, they discontinue business. So the 6,500 that we have now is very different than the 6,500 that we had 4 years ago. So when we're looking at trying to manage getting into all pharmacies once every 4 years, we have to recognize that that target is absolutely moving because our pool of pharmacies is constantly changing. So we're trying very hard to meet that mark, but I don't know how it's always going to be a moving target because our licensee population is so fluid. So what this slide represents is of those that are licensed, so our current licensee pool, when did we inspect them? So we did remove, if you look at the bottom number, it's at 6,200, and that's because we did remove pharmacies that had been licensed for less than a year. So for all of the pharmacies that have been licensed over a year, when did they receive a routine inspection? And so if you look, 507 of them were inspected within the first year of licensure. 1,223 were inspected within the first 2 years of licensure, et cetera. When you look at, though, the number that is, the numbers get larger, which is a problem. But then if you also look, we've got over 2,000 pharmacies that have not been inspected at least before 2013. And I know that that seems like a random date, but our data systems are a little limited here, so we don't have a lot of the historical inspection data. So it's possible that some of those have been inspected, but we can say with pretty good confidence that they have not been, routine inspection has not been conducted on about 2,000 of our current pharmacies. So we need to continue to move towards meeting that policy goal, because the education and early identification of corrections and violations and trying to catch that early is really important, not only to the licensee, but to the consumer that could negatively be impacted by those issues. Next slide, please. Again, we're going to talk a little bit about duty to consult, because that has been an area of interest to the committee. So in fiscal year 1920, 39 of our routine inspections revealed issues with noncompliance, with issues with patient consultation. So that's about 8% of all of our inspections identified problems with consultation. Further, in 20% of those, it was consultation was not even being provided. So as I said earlier, you know, there's a spectrum of patient consultation requirements, right? Did a patient not receive the notice through a mail order, or, you know, it was delivered, versus the patient that is there present in the pharmacy that is not being offered the consultation. So that's our data with that one specifically as well. Again, just the call out, because that is something that has been of interest to the committee in the past. So with that, that is kind of an overview of our routine inspections, and would be happy to answer any questions, as well as hear from committee members about what data points you found interesting, or those that you would be interested in us integrating in moving forward.
Thank you, Ann. Before we go to public comment, I would like to ask members if they have any questions or comments for Ann. Remember to unmute yourself and identify yourself before speaking.
Maria, this is Debbie Veal. I have a couple questions.
Go ahead.
And my first question is, and I don't think you said this, but, you know, maybe I wasn't paying as good of attention, but when you go in and are visiting a pharmacy for a consumer complaint, do you also at that point in time do a routine inspection, or do you only focus in on the complaint?
No, we are using that as an opportunity to also do a routine. Okay.
So I think, so when we saw the routine and we saw the complaint, was the routine ones there, those were just routine and there was no complaint involved, or were those potentially also in the complaint?
No, they would be, they're separate data sets. So we would have done a routine as part of it, but we did not double count it. The 507, those are the true routines, yeah.
Okay. And then one of that last slide, you said that 39 you found consultation issues. And did you say that was like 8% of the routine inspections you found consultation issues?
Yes, of the true routine. So of that 507,
you only found 39 with consultation issues?
Yeah.
Okay. I mean, that's actually great. I was expecting not as good of a number. I was expecting to have a higher percentage of the pharmacies having consultation issues. So that's actually, I think, good news to me. All right. Thank you very much.
Chair, I have a question. This is Albert.
Go ahead, Albert.
Yeah, and the goal and objective of Board of Pharmacy is consumer safety and protection. And if we could accomplish this by education, we should emphasize it. So I'd like to see the inspector do more education. I think we're improving that department. I'd like to continue to see they doing that. Okay.
Any response or?
Oh, no, we're working on that education, and that's why we do have all of those standard items as well as anything that the licensee wants to talk about. We do engage in discussion while we're there. And like I said, I think that we agree that, if we can catch things early before they become bigger, the world is a better place and consumers are safer.
Thank you.
Exactly. Thank you.
Any other member comment or questions? Anna had a comment or a question on, I think it's the previous slide that talked about the number of routine inspections over the year. That one. Am I reading this correctly? If we have about 6,500 licensed pharmacies, does the last, as a chart gets towards the bottom, does that mean that there are a third of our currently licensed pharmacies that have not been inspected in the last 7 years?
Yes.
Okay. So
I can't sugarcoat that. Yes, that's what the data shows of our current licensee population. What this slide doesn't capture, Maria, is we've done more inspections, right?
Right.
But licensees drop out of the pool. And so
Right.
that's not captured here, right?
Right.
This is just a snapshot in time of our current licensee population. Where do they fall in? But I agree with you, that number is way too high.
Well, I'm wondering if there is a process to prioritize those that have been the furthest out to have more routine inspections, or how that could be monitored more closely.
Yes, I agree that we need to. So it's hard to know, like those that were inspected within the last year, were those also really old or were those recent? It's hard to know because we don't have super good data systems. So I do think that we do absolutely focus on the older, but we're also trying to take advantage of geography and other things as well. But absolutely, that should be one of the priorities when making these kinds of assignments.
Great, thank you.
Yeah.
Any other member comment? Let's now open the discussion for public comment. Moderator, please open the lines as appropriate.
All right, this is the moderator, and at the direction of the chair, I have opened up the Q&A feature for public comment. Members of the public, the Q&A feature is now open. If you would like to make a public comment, please click on the icon with a question mark within a square located at the bottom center of your WebEx screen. We're currently sharing slides for your reference. And as a reminder, if members of the public would like to participate in public comment, you must enter the WebEx event through the link provided with the agenda. And I do have one individual who has indicated they would like to make public comment. Individual identified as Stephen Gray. Give me one moment while I pull up my timer. All right, Stephen, you will be given 2 minutes to speak and a 10-second warning. I am unmuting your microphone now.
Thank you again. Thanks again, Ann, for that presentation. It's very helpful and it really gives a good picture. One of the things it doesn't talk about that I am still hearing from payers, PBMs and other payers, there are still problems, and I don't know the quantity, if any, in California, but there are still problems with pharmacies that are not pre-inspected before they're given a license, getting a license, using that to get an NPI number, and then submitting billing from borrowed or purchased tapes of prescriptions to the payer, when in fact the pharmacy never did exist, either physically at all. And in fact, some of these payers now have had to hire teams to go out and visit pharmacies that they get new billings from to make sure that their pharmacies actually exist. And so that may be something that I know that some boards of pharmacies have tried to resolve that by getting data from utility companies or going in on the web and seeing if there's a GPS view of the pharmacy location at that address. But literally, I just wanted to bring that up as something that is continuing to happen, has been happening apparently for quite a number of years. Thank you very much for the ability to comment.
Thank you, Dr. Gray. Anne, do you have any comments about that concern?
We are not resourced to do inspections prior to issuing licenses. We do that for the sterile compounding and the outsourcing, but it's a resource constraint. I think that the board's policy has been more focused on routine inspections of existing licensees, but if that is a policy priority, we can figure out how to try to make it work within our existing resources, but there's a bit of an offset. I do think that we have provisions in the law. I can't speak to other jurisdictions. We have the 4312 provisions that do allow us to cancel a license under certain conditions. I don't think that we issue a license willy-nilly, and I think our pharmacist applicants would agree. We do our due diligence and background. I think that the decision point for the board would be if you believe that that is a higher risk than some of the other risks that we currently, are dedicating our resources to. It would be something that we would need to figure out.
Thank you.
If I can just say one other thing, a payer can always file a complaint with us, and I'll stop there.
Thank you. Any other public comment?
This is the moderator. There are no individuals who have requested public comment. Would you like me to close the Q&A feature now?
Yes, please do. Thank you.
Great. The Q&A feature is now closed.
We'll move on to our next agenda item, number 6, discussion and consideration of board enforcement statistics. Members, included in the meeting materials is a summary of the data on the enforcement statistics. Subsequently to the release of these materials, final fiscal year numbers were also provided and posted on the website. So you would see that as additional meeting materials in that section. Because of the timing of this meeting, additional statistics, including the multi-year comparison, will be provided during the board meeting held later this month. Based on my review of the fiscal year statistics, and so this is looking at the grid that was in the additional materials package, the board received 2,647 complaints and closed 2,910 investigations. It appears that the average days for investigation is also trending downward. During the fiscal year, the board issued 327 letters of admonishment, issued 1,428 citations, and referred 230 investigations to the Office of the Attorney General to pursue administrative cases. The board filed 248 accusations during the time period, and disciplinary action was taken in a range of outcomes from revocation of licensure to public approval of license. The board also secured 16 immediate protection orders, including 8 interim suspension orders, 2 automatic suspension orders, 5 Penal Code 23 restrictions, and 1 cease and desist action to an unlicensed location. If you look at the next part that I'm going to briefly review is on page 4 of the chair's report, summarizing some turnaround time studies. So in this material, information on pending cases that provide the average days in general investigative steps from assignment through the investigation and the various levels of review. It is good to see that the average number of days cases under investigation has decreased.
I will have Debbie let Solid know, and we'll have
Sorry,
to open it.
Anne,
We'll let
can you mute your phone? Sorry, Anne. Thank you. It's good to see that the average days for cases under investigation has decreased from our January meeting. In January, the average number of days was 186, and currently in the report it states 170 days. I note the most significant improvement is with the supervisor's review, where the decrease in time went from 107 days reported in our January meeting to 41 days as reported in the current report there. I do note that it appears that the second level review time has doubled from an average of 20 days to currently an average of 42 days. I'm hopeful that our next report will show some improvement in this area. Before we go to public comment, are there any member comments or questions on the data as provided? Any member comment? Hearing none, open the discussion for public comment. Moderator, please open the lines as appropriate.
All right, this is the moderator. I open up the Q&A feature for public comment. Members of the public, if you would like to make a public comment, please click on the icon of a question mark within a square located at the bottom center of your WebEx screen. We're currently sharing instructions for your reference right now. As a reminder, if a member of the public would like to participate in public comment, they must enter the WebEx event through the link provided in the agenda. All right, and at this moment, it looks like there are no requests for public comment. Would you like me to close the Q&A feature now?
Please do, thank you.
All right, thank you.
Members, before we adjourn, I'd like to remind all of you that our next meeting is currently scheduled for October 27th. I'd like to thank everyone who made presentations today. It was a long...
Maria, that's the same day as our licensing committee meeting. Is it we had different time?
My understanding is that the meetings may be on the same day, but they're at different times.
Yeah, so it have to be one in the morning, one in the afternoon.
Yes, I'm sure that they'll make it so that the meetings are not running at the same time. Thank you. So before adjourning, I'd like to thank all of the presenters for their detailed information and patience with the questions from the members and from the public. And thank members of the public for listening to these educational opportunities. We're hoping to learn a lot about the processes and to improve upon them over time. So I appreciate everyone's participation. With that, unless members have any additional comments, I'd like to adjourn the meeting and thank you all for your attendance. Moderator, you may end the meeting. Thank you all.
Good job, Maria. Good job.
Thanks, Maria.
Thanks,
Good job.
Albert. Thanks all. I appreciate everyone.
All right, this is the moderator, and this concludes the Enforcement Committee meeting. I will now close the WebEx event now.
Everybody stay healthy.